Can you check if I'm audible? I'm audible? Good afternoon, esteemed panel. We're just waiting for one more judge to join, and then we will begin our rounds.
Okay.
And good afternoon, everyone else. Hope you're fine today. It's my honor to be with you.
Good afternoon to everyone. It would be a pleasure to share the bench with esteemed members.
29th edition of the Surana and Surana Indian National Rounds for the Stetson International Environment Law Moot Court Competition 2025. Please, we are truly privileged. I would congratulate, before I begin, I would like to introduce the judges on our panel today. We're truly privileged and honored to have Her Ladyship, Honorable Justice Shalini Joshi Phansalkar, a former judge of the High Court of Bombay. Her Ladyship is a trailblazer in the legal and judicial arena, renowned for her exceptional intellect, compassionate leadership, and over 31 years of distinguished service to the judiciary and society. Her Ladyship's illustrious career has been marked by several pivotal roles, including serving as the Principal Judge of the City Civil and Sessions Court, Mumbai, the Registrar General of the Bombay High Court, and as a judge in specialized courts addressing critical issues such as women's rights and juvenile justice. Her expertise in these sensitive and vital areas reflect her deep commitment to upholding justice and fostering societal well-being. A passionate academician, a thought leader, Her Ladyship holds a doctorate in law from Pune University, with her thesis focusing on the pressing subject of child sexual abuse, a socio-legal perspective, an area where her contributions have been both scholarly and transformative. As a British scholar in gender and law, a Commonwealth Judicial Education Fellow in Canada, she has gained global recognition for her groundbreaking work in advancing judicial thought and gender justice. Her Ladyship has also served as the officiating director of Maharashtra Judicial Academy, where she played an instrumental role in shaping the future of the judiciary. Through her tireless efforts, she has trained judicial officers, prosecutors, police personnel, and other stakeholders at both the state and national levels, leaving an enduring legacy of judicial education and reform. Even after her illustrious tenure on the bench, Her Ladyship continues to enrich the legal landscape through her active contributions to academia, arbitration, mediation, and legal consultations. Her unwavering dedication in the pursuit of justice and her profound insights into law and society have made her enduring inspiration to all. It is an absolute honor to welcome Honorable Justice Shalini Joshi Phansalkar, a true pioneer, visionary, and stalwart of the judiciary, in today's final rounds of this competition. Next, we are profoundly honored to welcome His Lordship Honorable Sri Justice M.N. Khilani, a venerable legal luminary whose remarkable career reflects decades of unwavering dedication to the judiciary, justice, and public service. Hailing from a humble agricultural family in Yavatmal, Maharashtra, His Lordship's journey exemplifies the power of perspective and intellect. After earning a BSc and LLB, His Lordship embarked on a legal career in 1975, enrolling as an advocate and quickly distinguishing himself as a promising legal mind. Recognizing his immense potential, His Lordship joined the judiciary in 1980, a decision that would herald an era of judicial brilliance and administrative excellence. Through an illustrious career, His Lordship has served with distinction in key judicial and administrative roles, leaving indelible mark on the legal landscape of Maharashtra and beyond. Among the pivotal positions he has held are Chief Metropolitan Magistrate, Special Judge under the TADA and NDPS Acts, Principal District and Sessions Judge, Nagpur, each role executed an unwavering commitment to justice and rule of law. His Lordship's expertise extended into administrative excellence, as well as serving as Principal Secretary, Legal Remembrancer, and Registrar General of the Bombay High Court, where he contributed to the efficient functioning of the judiciary. In 2011, his Lordship was elevated to the High Court of Bombay, where his tenure was marked by his groundbreaking judgments, judicial foresight, and a profound sense of fairness. His Lordship retired in January 2013, concluding a stellar career that has inspired countless members of the legal fraternity and left an enduring legacy of judicial integrity, wisdom, and excellence. It is with the highest respect and admiration that we extend a heartfelt welcome to Honorable Justice M.N. Gilani, a beacon of justice and enduring inspiration for all of us. Thank you for accepting our invitation and grace us with your presence, Lordship. It is an immense privilege to introduce Professor Dr. Bharat H. Desai, a towering intellect and one of the most distinguished scholars in the field of international law and diplomacy. Currently serving as the director of the Institute for Advanced Studies in International Law and Diplomacy, Professor Desai's illustrious career has been marked by unparalleled contributions to academia, policy making, and global governance. Professor Desai is the former chairperson of the Jawaharlal Nehru Chair and professor of international law at the Center for International Legal Studies, School of International Studies, Jawaharlal Nehru University, New Delhi. He has been at the helm of thought leadership as the editor-in-chief of Environmental Policy and Law, contributing significantly to shaping global discourses in environmental governance and policy. His involvement in multilateral negotiations as part of India's official delegations has cemented his status as a global authority in international law. An intellectual powerhouse, Professor Desai has authored 14 groundbreaking books, 106 plus research articles, and 60 plus influential blog articles, making transformative contributions to global discussions on the reform of international institutions. His visionary ideas include the establishment of Specialized Agency for the Environment, UNEPO, the repurposing of the UN Trusteeship Council, UNTC, the creation of an International Environment Council, IEC, and the advancement of international environmental governance, all aimed at ensuring a sustainable planetary future. With an unparalleled dedication to nurturing future leaders, Professor Desai has supervised an astounding 120 PhD and MPhil dissertations, leaving an indelible legacy in academia. His expertise has been sought by esteemed organizations such as Union Ministries of External Affairs and Environment, Forests and Climate Change, the World Bank, the World Conservation Union, and the Asian Development Bank. Professor Desai's profound ideas on foreign policy, national security, and university reforms have reached the heights and echelons of Indian governance, including one-on-one presentations to Prime Minister Narendra Modi, his Principal Secretary, Mr. Nipendra Mishra, and Prime Minister's Office. Next, we wholeheartedly welcome Dr. B.P. Neelaratne, former Joint Secretary to the Ministry of Environment and Forests, Government of India, and Advocate, Supreme Court of India. We are deeply honored to welcome Dr. Neelaratne, a luminary whose unparalleled expertise spans the realms of law, science, and administration. Dr. Neelaratne's academic journey is nothing short of extraordinary. He holds a law degree from the prestigious University of Delhi, a master's in physics from the renowned IIT Kanpur, a PhD in physics from the esteemed University of Leeds, UK, and D.Lit in economics, an embodiment of academic excellence and intellectual versatility. With an illustrious career spanning over 34 years of distinguished administrative and scientific contributions, Dr. Neelaratne has left an indelible mark as a former Joint Secretary to the Ministry of Environment and Forests, Government of India. His global influence is evident through his representation of India at various international forums, including the Montreal Protocol meetings, where he played a pivotal role in shaping global environmental policies. as the national focal point for ozone, the Montreal Protocol, mangroves, and coral reefs, Dr. Neel Ratna has been at the forefront of driving impactful environmental initiatives. Adding to his illustrious portfolio, Dr. Neel Ratna has served as the National Project Director for the UNDP GEF project on medicinal plants, a role in which he championed the cause of biodiversity and sustainable development. His scholarly contributions, including numerous publications on energy, ozone, chemicals management, and environmental conservation, have been instrumental in advancing global knowledge in these critical areas. A man of many hats, Dr. Neel Ratna is also a seasoned legal professional, having advocated at the Supreme Court of India for over a decade. As the managing partner of Enviro legal defense firm New Delhi, he continues to blend his legal acumen with his unwavering commitment to environmental sustainability. Thank you for being here, sir. Our last judge on the panel today is Mr. Mohit Khubchandani, International Disputes Resolution Attorney. He holds a master's degree in International Environmental and Energy Law from Stanford Law and specializes in compensation metrics for environmental damages across major international courts. With over 8 years of judging experience at the Philip C. Jessup International Law Moot Court competition, he has presided over rounds across jurisdictions, including UK, India, virtual global platforms. His credentials further extend to the William T. Viz International Commercial Arbitration Moot, where he recently judged the 31st edition in Vienna, and the Telders International Law Moot, where not only he judged but also contributed to the case drafting for the 45th special edition. In environmental law, he brings valuable insights as a judge in the Stetson International Environment Law Moot, where he has judged Indian national rounds and global rounds over the last 5 years. His expertise spans space law as well, having judged the Manfred Lachs International Space Law Moot at prestigious North American regional rounds. As a frequent arbitrator for the UPH Foreign Direct Investment Moot, he has evaluated rounds in South Asia, Africa, and Europe. We are honored to have him judge as the judge for the 29th edition of this competition. Please join me in giving a warm welcome to the bench, and I hope that this round enriches both the judges and the participants for an enthralling experience. With this in mind, I would like to inform the judges that we have a timekeeper who will take the time division before the start of the rounds from the participants and keep a regular timestamp in the chat box for their perusal. Now, I would like to ask the permission of the judges to admit the participants so that we can begin with the rounds.
Yeah. Yes. Go ahead.
Right. Thank you. Should we let the teams in? Please allow me to welcome our finalists for the 29th edition of the Surana and Surana Indian National Rounds for the Stetson International Environment Law Moot Court Competition 2025. Congratulations to both the teams present here on making it to the finals of this competition. I would like to ensure that the finalists are connected to a stable internet connection, and I request them to kindly keep their video cameras on throughout the competition. Before we begin, I would like to request the finalists to clarify their time division for the round, starting with the applicant.
Put a time division in the chat.
Okay. Thank you.
So I think the presentation will take place in the order in which it is listed: speaker number 1, speaker number 2, like that. First the applicant, then the respondents. Is that fine?
Yes, sir.
Okay.
Yes.
Okay. Okay. Perfect. Please go ahead.
Now that we've received the time division of the participants, please ensure that you keep a constant check on the chat box for regular time stamps that will be posted by the timekeeper in the present round. We shall now commence the hearings with the applicant first.
Before I begin, could I request the timekeeper to stop the time when I finish speaking and restart when the second speaker starts, and not keep the time running between speeches?
That could be done, yes.
Thank you.
Thank you.
Also, could we know who the presiding judge for this round is?
The president of this round would be Her Leadership Honorable Justice Shalini Joshi Fansalkar.
Thank you.
Thank you. Yes, you can proceed.
Madam President, Your Excellencies, my name is Kyle Correa, and I appear on behalf of the applicant, the state of Astor, with my co-agent, Samar Srinivas. I will be speaking for 21 minutes on Rishmak's auction of the royal marker, and my co-agent will speak for a further 21 minutes on Astor's ban on the import of royal marker hunting trophies. And we reserve 3 minutes for rebuttals.
Sure, go ahead.
Your Excellencies, we confront today an auction system that seeks to transform a sacred indigenous tradition into a commercial venture for wealthy trophy hunters. The states of Astor and Rishmak have both banned the taking of the royal marker. However, Rishmak has allowed an exception to this prohibition for its indigenous Dion Ginsu community. Since 2016, the Dion Ginsu have auctioned off this right to hunt 10 adult male markers annually. The critical question before this court is whether this auction complies with conventional international law. Your Excellencies, at the outset, I would like to state that we will be making two primary submissions. First, that the auction process does not fall under any of the exceptions which are laid out in Article 3.5 of the Convention on the Conservation of Migratory Species of Wild Animals. And secondly, we will be arguing that the auction process does not meet any of does not meet any of the three proviso conditions which are laid out in Article 3.5. Coming to my first argument, the taking of the royal marker as an Appendix 1 species of the CMS is banned under Article 3.5. Therefore, Rishmak has the obligation to establish that its exception which it has granted for the Dion Ginsu community falls within any of the exceptions which are laid out in Articles 35A, B, C, or D. Further, RISMAC has the obligation to establish that its auction meets the three conditions which are laid out in the proviso to Article 35. I will be arguing first the exceptions and secondly the proviso conditions. Coming to my first argument, which is under Article 35B of the CMS. This allows staking when it is for the purpose of enhancing the propagation or survival of the affected species. At the outset, I will be making two submissions under this exception. First, that the phrase "the purpose" in this exception must be construed narrowly. And secondly, that trophy hunting does not enhance the propagation or survival of the affected species, and in fact negatively impacts an endangered species conservation prospects. Coming to my first argument, which is that the phrase "the purpose" must be read restrictively and to mean the primary purpose. Your Excellencies, this court's decision in whaling in the Antarctic in 2014 had the opportunity to confront a similar exception in another environmental treaty, the International Convention on the Regulation of Whaling. In the International Convention on the Regulation of Whaling as well, there was an exception, which was, quote, for purposes of scientific research. In that case, Your Excellencies, in paragraph 72, to be precise, this court held that the phrase purposes must be read to exclude any incidental purposes. And if the purpose was merely included in a measure and did not have it as its driving factor, it would not qualify under this exception. Similarly, in this case, let us look at where the funds of the auction are going. As paragraph 16 of Annex A to the record tells us, 15% of funds only go towards conservation. The rest of the funds go towards meeting the community's needs, that is the Dion Ginsu's medical and health needs, and 10% of the funds go towards the auction's costs. Since only 15% of funds are going towards conservation, this can hardly be said to be the primary purpose, and therefore
I have a question for you. So you cited to us the whaling case by the ICJ, and insofar as I remember, scientific research in that case was not qualified by an explicit statement, as we do in our case, on a 15% designation for conservation purposes. We did not know in the whaling case whether the scientific research did or did not amount to conservation activities, which we do here. And the next thing, what I wonder is, what, according to you, is the magic figure then? If 15% is not too much for you, then what would be too much and what would be too less?
Certainly, Your Excellencies. Your Excellency, in the whaling case, this court had the opportunity to interpret the phrase "the purpose," and in this case too, there is no limitation as such given in Article 35B of the CMS. We are merely pointing, Your Excellency, to the facts of this case, which is that only 15% of the funds that are generated go towards conservation. In that case, since a court had interpreted a phrase, an exception rather, with a similar word to ours, we urge this court to look at its prior precedent and hold accordingly. Secondly, as to a figure that we can pin down for this exception, there is no singular figure as such. However, 15% is far too less of a figure for it to qualify as a driving factor, which this court held is an essential when we are confronted with such exceptions in environmental treaties. This is to ensure that these exceptions do not become too wide and the purpose of the conservation treaty is defeated in the process. Secondly, Your Excellency, in this court's decision again, in arbitral award of 3rd October 1899, this
Sorry,
court...
just one more question. Do you think that the sub-provisions of Article 3.5 have a conjunctive or a disjunctive test?
Your Excellency, under Article 3.5, any one of the exceptions needs to be fulfilled by RISHMAC. We will show that neither of the two exceptions that RISHMAC has claimed, along with the third exception which they might claim, are fulfilled in this case. Your Excellency, in this court's decision in arbitral award of 3rd October 1899, this court had the opportunity to look at a phrase with a definitive article "the." Similarly, in this case, we are confronted with an exception which uses the language "for the purpose." Here too, "the" must be interpreted narrowly. That is, it creates a closed list. It is not an inclusive or open-ended word, and therefore other purposes cannot be smuggled into a conservation measure. With this, Your Excellencies, we have shown how a narrow reading of Article 3.5b must be conducted. Moving on to a second limb under this exception, Your Excellencies, trophy hunting negatively impacts the conservation prospects of endangered species. Your Excellencies, I will begin by demonstrating a case study of a species which was endangered and which had a trophy hunting program which was implemented and where conservation funds were again generated from the auction. This is the case of the lion. And when the Zambian government had prohibited and imposed a moratorium on trophy hunting, this lion had increased in numbers. So when the lion had hitherto been in decline when trophy hunting was implemented, once the government had stopped this trophy hunting, we now witnessed a rise. And this points to how trophy hunting, because of its short-term incentives, actually incentivizes locals and traditional users to generate as much funds in the short run as possible. And they therefore do not have regard for the long-term survival prospects of the species. Looking at the case before this court over here, the royal marker is a critically endangered species, as paragraph 1 of Annex A to the record tells us. There are only 2,200 individuals left of this once magnificent species. Of this 2,200, 20% only are male adult markers. And adult male markers are the markers which are favored and hunted through this trophy hunting process because of their horns and hide. Your Excellencies, 20% is merely 440 royal male markers, of which 10 adult male markers go every year to this auction process. This is a rather small number that is being hunted in this case, and applicants have the responsibility to point us to other trophy hunting programs which they claim may have been successful, where such a small number of the species were being targeted.
Agent, I think that we might be jumping the gun a little bit here, because the first question that you need to answer to us is whether within the reading of Article 3.5 of CMS and the ARTA, can trophy hunting be done when particularly it's being done by peoples and by the indigenous communities? And that, at least what I think as per the IUCN guidelines, is permissible. And then we can come to whether or not trophy hunting leads to conservation of the markhor species or not, because I think it's a case-by-case analysis. In some cases, trophy hunting does lead to conservation. So the first question, I'll be very grateful if you can answer whether it's even permissible or not.
Your Excellencies, at the outset, trophy hunting falls under the taking, which is prohibited under Article 3.5, since the royal marker is an Appendix 1 species. However, we do not contest that there might be a few isolated examples of trophy hunting which were successful and therefore may fall under any of the exceptions. We contend that the trophy hunting that is at issue before this court is not one of those instances. And in fact, applicants have respondents have a responsibility to show us the mechanism through which such trophy hunting would be permissible under any of these exceptions. Moving on, Your Excellencies, the mechanism of trophy hunting must be demonstrated by the respondents. Over here, they may point to certain case studies, and there are certainly case studies. However, they have to show at the level of incentive how conservation is being incentivized for local users. And if,
Hello, one question.
certainly, Your Excellency.
Yeah, you talk about this 20% of the male population, whether this 20% is because of the hunting is allowed, and what was the percentage when hunting was not allowed?
Your Excellency, at present, only 20% of the marker is adult and male, and we do not have figures to demonstrate what the number was before hunting was allowed. But
But
the
is it a natural ratio? Is it 20% is a natural ratio? Because in all species, male percentage is less.
certainly, Your Excellency, we do not have any information as to whether this is a natural ratio, but there are certainly indications to point to the fact that because the male marker is prioritized and preferred for hunting because of its horns, which have been part of the Dion Ginsu's traditions, that might contribute to the males being lower in number as compared to the females.
No, can I I'll just make a little submission on this issue. Like you flag the issue of a particular tradition, for instance, and while uh, every multilateral environmental agreement, and in particularly like the CMS, for instance, that the conservation agenda per se, so whether it enhances conservation or not is a different matter. But the very fact that is they are compromise, okay, struck in order to woo the parties to be part of the whole thing, So the very idea of when you highlight the whole issue of like taking, for instance, and every convention is subject to those kinds of. So whether that falls under the tradition which is being claimed, because this is just the number was also earmarked just 10 male member, which will be hunted, whether it is contracted out to some other parties or not. But the very fact that is a token incentive you have to allow to a state party to be party to the convention. Otherwise, it's not a like black and white, for instance. Is that correct?
Certainly, Your Excellency. You raise a very important point that the CMS is in fact the attempt to strike a delicate balance between conservation and certain other needs. However, this balance must be strictly respected, and this balance is in fact laid out in Article 3.5, which lays out when conservation might in fact be detracted from. And these exceptions, we argue, is on the respondents to fulfill, which we will show through our arguments why they cannot, based on their submissions in written pleadings, as well as from the record. Your Excellency, since the data on the benefits of trophy hunting for conservation are so ambiguous, and there's uncertainty as to whether trophy hunting actually benefits the species, we must look at the precautionary approach, which this court has endorsed in the case of pulp mills. The precautionary approach tells us that when we have ambiguity or lack of certainty, we should err on the side of caution, and we should seize and halt any activities which even might cause harm to a natural resource. In this case, since there is such ambiguity over whether the trophy hunting could actually harm the endangered species, we urge this court to adopt this precautionary approach and halt the trophy hunting. Moving on, Your Excellencies, there's the second exception, which is under Article 35C. This exception, which Rishmak might claim, allows taking when it is to accommodate the needs of traditional subsistence users of such species. Here we say that the ordinary meaning limits this exception to direct use. And secondly, that subsistence needs excludes commercial needs from its ambit. Your Excellencies, we state that this exception is limited to direct use. If we look at analogous treaties, such as the Whaling Convention, which we argued earlier, there is an exception for aboriginal subsistence whaling over there too. However, in that case, it was limited to the direct use of the traditional Aboriginal people. It was not meant to be auctioned off and transferred to foreign trophy hunters, as is happening here with the Dion Ginsu transferring the right to hunt the royal marker to foreign and especially Astori trophy hunters.
Now,
Agent,
let me chip in here. Like you cited twice this question of the well hunting, for instance. And the so-called exception. The scientific well hunting, etc. So again, isn't it a kind of a model when although there is no precedent, it doesn't have a binding effect so far as a particular case is concerned and the particular parties are concerned, that precedentially value by virtue of the statute itself is not permissible. But notwithstanding that, the very fact that since if you push it beyond the point, for instance, and immediately in that Welling case, it happened that although the court went on pleading and on this prohibition, etc., Japan simply refused to comply. They said we will walk out of the convention. So that is the red herring, in that sense, So if you don't allow this kind of a permissible, this kind of a little flexibility within the convention, whatever way, whether it leads to, because most of the tools and techniques which are put into these conventions, they are simply like by trial and error. Nothing has, no research indicate that they have actually per se helped. There are local factor, conservation is a different ball game, etc. So how do you react to that?
Certainly, Your Excellency. However, in this case, we would like to underscore the criticality of the issue over here. In this case, the royal marker is a critically endangered species, and we have a rapidly depleting number of the royal marker. Allowing even 10 adult male markers to be hunted every year could harm the reproductive cycle of the royal marker, and they take away with certainty 10 adult male markers from a species which is now in the hundreds. Your Excellency, this is not a case where we can permit even the smallest deviation from the exceptions as laid out in the Convention on Migratory Species.
Excuse me, since how long this 10% royal markers are being taken away?
Apologies, Your Excellencies. Could you...
Since how long? Am I audible?
Yes, Your Excellency.
Okay, since how long, how many years this is going on, 10%, royal markers being hunted?
Your Excellency, since 2016, the Dion Ginsu have auctioned off.
Do you have any data to show that because of this, the number is reduced?
Well, Excellency, we do not have any data as such, but because of the fact that the royal marker is an endangered species, and because we know there is also a disease which threatens its survival, this only points to the criticality of ensuring that the numbers of royal markers which are there, we should preserve them as much as possible and not allow them to be taken even more through this auction process. Your Excellency, this brings me to the second limb of my argument, which is that subsistence use excludes commercial use from its ambit under Article 35C. Your Excellency,
in the interest of time also, I have a question both on Article 35B and C. Now, you're using the VCLT's plain and ordinary reading, but what perplexes me is that when you do your reading of Article 35B, you tell us to have a restrictive view. And the relevant phrase is taking is for the purpose, quote unquote. Whereas in 35C also you ask us to take a restrictive view, but the language there is taking is to accommodate, quote unquote. It is not taking for the purpose. It's not the same language as 35B. So when you say that the measures taken are even commercial in nature and not necessarily entirely subsistence, we think that the language of 35C is broad enough insofar as the needs of the Dinzo community, even commercial needs, can be taken care of, because it's accommodating other conservation activities as well, and is coming as a broad package, a mutual benefit package of sorts. It is not solely for the purpose of traditional subsistence, is my reading. Unless you tell me that you are willing to take back your reading of 3.5b.
Certainly, Your Excellency. Noting that my time has elapsed, I would request for a minute or so to answer your question. To begin with, I will answer this in two parts. First, that exceptions in international law must in general be narrowly construed. And secondly, that the word traditional that has been used in this exception is of import. In the Travo repertoire, we noticed that the word traditional was not previously included in Article 35C. It came in later, and therefore this inclusion is of some significance. And to allow the exception to be broadened to the extent that it includes even other foreign trophy hunters, this would defeat the purpose of restricting it to only traditional subsistence users. Finally, Your Excellency, I will very quickly wrap up my argument under the proviso, which is that this auction process does not meet any of the proviso conditions. Rishmap does not give us the fixed territory of where the hunt may take place, nor has it told us how long this hunt will go on for. Moreover, as we have established, this is to the disadvantage of the species. Trophy hunting negatively impacts a species' conservation prospects. Since we have established that the proviso conditions are not being met over here, even if Rishmap's auction falls under any of the exceptions, it violates conventional international law. Therefore, we urge this court to hold in favor of the applicants. Much obliged.
Thank you. Yes, who is speaker number 2? Speaker number 2 can resume.
Your Excellencies, I will take apology. Can I confirm with the
Yes.
that I am visible and audible?
Yes, please proceed.
All right. Much obliged, Your Excellencies. Madam President, Your Excellencies, under issue 2, we submit that the import ban is consistent with conventional international law. At the outset, we would like to draw the attention of Your Excellencies that the ban, which we shall hereinafter refer to as the measure, is not just on royal mark or hunting trophies, but on all hunting trophies, and we will analyze it as such. We will make two submissions. The first is that the measure is consistent with the Astor-Rishmack Trade Agreement, that is the ATA, and the second is that it is consistent with the Convention on the International Trade in Endangered Species of Wild Fauna and Flora, that is the CITES. I come first to my argument on ATA. The measure is consistent with the Astor-Rishmack Trade Agreement. Now, Your Excellencies, this agreement closely resembles the General Agreement on Tariffs and Trade, and the parties have accordingly agreed to treat World Trade Organization case law as a subsidiary source of law to interpret the provisions of the ARTA. We will therefore be placing reliance on WTO law in this regard. In order for the measure to be lawful under ATA, it must first be provisionally justified under one of the sub-articles, and second, must meet the requirements of the chapeau, which is of such nature as a proviso. I will argue first that the measure is provisionally justified under Article 20A, second, that it is provisionally justified under Article 20G, and third, that it meets the requirements of the chapeau. To begin with my first argument, the measure is provisionally justified under Article 20A of ARTA as necessary to protect public morals. At the outset, the public morals objective of the measure is to curb the involvement of Astor's nationals in foreign trophy hunting. The requirement to prove justification under this article, as was most recently applied by the panel in US tariffs at paragraph 7.112, is that first, the measure must concern public morals. Second, it must be designed to protect public morals. And third, it must be necessary for the protection thereof. Firstly, the measure concerns a public morals objective. The phrase public morals was defined in US gambling to mean the values maintained by or on behalf of a community or a nation. WTO members have been given a large measure of deference in defining the scope of their public morals. This is because a party has the sovereign right to define what constitutes public morals according to its own system of values. Now, Your Excellencies, as per the report of the appellate body in EC Seals, it is sufficient if the legislators who enacted the measure perceived it as a public morals issue. But in any case, we will demonstrate to Your Excellencies that the measure is grounded in the concerns of Astor's citizens as well. If I may direct Your Excellencies to paragraph 28 of the record, you will notice that surveys of Astor's citizens have shown that the vast majority of citizens have been consistently opposed to trophy hunting over the years. Your Excellencies, this is because the trophy hunt has morally salient features in that it is invariably cruel and inhumane. If I refer you to clarification 3, to the clarifications to the record, which form part of the agreed statements of facts, you will notice that the female marker, 2 weeks in advance of the hunt, is trapped in a facility with a sloped cement floor. They spend those 2 weeks in extreme discomfort while their urine is discollected to trap the male marker for the purpose of the hunt. Coming to the actual hunt, once the animal is initially wounded, it is tracked for an average of 3 hours before it is then subsequently killed. We submit, Your Excellencies, that this is a demonstrably cruel and inhumane hunt. It outrages the moral sensibilities of Astor's public, and the measure therefore concerns public morals. It is also designed to protect public morals.
Agent, sorry, I do disagree with you here because, if you say that countries are free to decide what they qualify as public morals, what you're doing is creating a lot of inconsistency and opening a Pandora's box. Because, there are several sensitivities, including religious and cultural, involved in the world. I'll give you a very small example. Now, there is a preference in some cultures to eat meat that is halal and not halal meat, for example. Now, we all know how halal meat is produced. Do you think that the way the royal markers are being killed here is more or less cruel than how halal meat is prepared? And if it is on the same pedestal, then dealing in poultries can also be banned under the WTO regime when certain ways of processing meat are more towards public morals being affected. Because the EC Seal case was a very peculiar one, and before that, such kind of exceptions were for other things such as corruption and gambling. In this case, there was a public revulsion on how the seals were being killed. But the way that the royal markers are being killed is how hunting, unfortunately, happens all over the world in many kinds of species. So I don't know what is it that is so pressing that should make this exception. And in any case, the seals case that you've mentioned also contained an exception for indigenous communities to do such kind of killings, which is also the case here.
Your Excellency, we recognize your concern and we agree that a party does not have unfettered discretion under Article 28 to define the scope of morals. What is necessary, however, is that they demonstrate, by reference to evidence, as we have done, that there is some value important to the nation that they are invoking. We submit, Your Excellencies, that there cannot be a uniform standard for public morals precisely because state parties have the sovereign right to define what constitutes public morals according to their systems and values. In fact, if we look to the negotiating stages of the General Agreement on Tariffs and Trade, Article 20A was a crux during that stage, and parties thought it very important that they retain the discretion to define what constitutes a public morals objective. And therefore, we submit that it is sufficient if we show you that Astor's public is outraged over the moral features of this hunt. It may be the case that in a different country, they would not be so outraged, but that country would have to once again invoke the exception in respect of its system of values.
Whether it would be amounting to one country imposing its own standards on another country which is sovereign independent?
Yes, Your Excellency, we recognize your concern that we should not be extraterritorially imposing our public morals views. However, the import ban only applies to Astori nationals who engage in trophy hunting. And so, if any other hunting, that is by the indigenous community itself, is taking place within Rishmak, the import ban has no bearing on it. We only seek to curb the involvement of our own nationals in such hunting.
So, agent, again, it's a very untenable argument that you find it appalling to public morals, the fashion in which the markers are killed, and you have a problem with the imports, but domestically, the bill that came up, that bill never passed, and domestically such hunting is permitted. So what happens to the public morals when it is being done internally in the country?
Yes, Your Excellency, we recognize your concern. For one, we submit there are significant differences between the trophy hunting that takes place in Rishmak and that which takes place in Astor. For one, the prohibition of the royal marker is still forbidden within Astor, and so Astori nationals are not allowed to take the marker even within Astori territory. However, as you note correctly, there is no general ban on domestic trophy hunting. But the species which tend to be hunted for trophies within Astor, as you will find in the clarifications to the record, are panthers and bobcats, which are not endangered species. We submit, therefore, that the same considerations do not arise. And in any case, Article 28 of the ATA does not have a requirement that import restrictions be made in conjunction with domestic restriction. Where there is such a requirement, it has been expressly provided. Now, Your Excellencies, as part of 20A, I must also prove that the measure was necessary to protect public morals. And part of this necessity analysis is that the measure must be proportionately trade restrictive. Now, we caution that respondents may come and argue that Astor had less trade restrictive alternatives available to it. However, the assessment of necessity is a holistic one. The trade restrictiveness of a measure cannot be analyzed separately from its objective. Since the objective, as we set out, was to curb the involvement of Astorian nationals in trophy hunting and not merely to deter it or to make it more expensive, less trade restrictive measures, such as tariffs, for instance, would not meet this objective. And so we submit that the measure was necessary to protect public morals. But in any case, Your Excellencies, if you are not satisfied that the measure is provisionally justified under Article 20A, we can also show that it is provisionally justified under Article 20G. And so long as it meets the requirements of the chapeau to ATA as well, it will still be lawful under ATA. What we are required to show under Article 20G is that first, the measure must relate to conservation. Second, it must be about an exhaustible natural resource. And third, it must be made in conjunction with domestic restrictions. I begin with the first argument that the measure relates to conservation. Now, Your Excellencies, the standard of review that an adjudicator has to apply when looking at whether a party is enacting a measure that relates to conservation was laid down by the appellate body report in Brazil retreaded tires at paragraph 7.77. The standard is not that we have to show detailed evidence to prove beyond doubt that trophy hunting harms the conservation of species. What we merely have to prove is that there is enough evidence for Astor to apprehend a risk to the survival of the royal marker, and on the basis of this evidence, therefore, enact mitigating measures to protect its status and to prevent its population decline. We submit that we specifically apprehend a risk to the royal marker, one, because of its small population, two, because of the fact that within this population, 20% are adult male markers, as my co-agent has addressed at some length, and this is a specific population that is hunted for trophies. Now, respondents, of course, may come and give you case studies of examples where trophy hunting has promoted the conservation of species. We do not dispute that these case studies exist. However, as we have said, the standard of evidence for us is just to prove that we can apprehend a risk. And furthermore, they must prove, and this burden is on the respondents, that these case studies are sufficiently analogous to our present case. They may cite to you, for instance, the case study of the black rhino, which is hunted for trophies in Namibia and South Africa. However, in that case, the trophy hunt only permits the taking of old rhinos, which are beyond reproductive age. Other trophy hunting programs that generate revenue for the conservation of wildlife do so by directing revenue towards things like habitat preservation and anti-poaching efforts. In our present case, the funds that are raised for conservation only go to a singular purpose, that is the development of vaccine for a disease that afflicts the royal marker. We do not know if this disease can be mitigated by a vaccine. We do not know if these funds will ensure that a vaccine is developed. We do not know the time frame within which a vaccine can be developed. These are all uncertainties which are actually we submit must rule in our favor. I have submitted yes, Your Excellency.
Agent, the way that you're flagging certain uncertainties right now, and I'm going to follow up on Madam President's question to you earlier as well. There is also an uncertainty as to whether it's indeed just the auction killing or other contributing factors too that could be leading to the decline of the markers. As a matter of fact, in the past few decades, the markers have disappeared from few countries in Central Asia and are now only in the applicant and respondent state. And certainly that has got nothing to do with the respondents' trophy hunting activities. It could be climate change, it could be soil acidification, so many other factors, as is the case with many other endangered species. And also, Article 20G relates to exhaustible natural resources, and I don't know if natural resources also means species, but instead just includes minerals and other components of flora.
Yes, Your Excellencies. Certainly. So, to address the first part of apologies, Your Excellency, I am forgetting the first part of your question.
What is proof that it's only the hunting activities that's causing a decline? Why are such speculations not being made for other things as well?
Yes, Your Excellency. We do not contend that the hunt in Rishmak has been the sole risk to the survival of the species, or that has been the sole factor that has led to its population decline. There are, of course, other factors such as poaching and habitat loss. However, given that now the species is in the state that it is, critically endangered, we submit that we cannot tolerate any further risks to the population level. And so, notwithstanding the fact that there are other factors which contribute to the species' detriment, and these are factors that, of course, both countries, we hope, will try to address, we can do what is within our power and prohibit the respondent from unlawfully auctioning off their hunting rights, which is causing detriment to the survival of the species.
So if we asked the respondent to sign a settlement with you, and just like the Namibian example that you gave to us, if we sign a settlement that the 10 takings per year would be of 10 markers that are about to finish their lifespan, would you be agreeable to that arrangement?
Your Excellency, so long as the markers are being taken by the indigenous community themselves, which is permitted under the provisions of the CMS, if such a settlement were proposed to us, we would of course be amenable to it. pending instructions that we may take.
So would you not want to check with your scientific experts that even that taking can detriment their conservation activities?
Of course, Your Excellencies, we would have to make a more detailed analysis of whether such a proposal would, like what effect it would have on the conservation of the species. But certainly, the hunt as it stands today, we submit, is far too detrimental and far too risky to be allowed. Now, Your Excellency, to address this,
Just a minute.
Just chip in here,
Okay.
the very fact that you are amenable to concede that point, does it not compromise in terms of the larger conservation argument which you yourself are making? Because most those who are familiar with the entire conservation agenda know very well that things don't work mechanically. They don't work this way. Okay, it doesn't work this way that you have this thing and then automatically the conservation figures will go up. Because that kind of inbuilt latitude or flexibility is part of the whole those who are familiar, because CMS is basically it's a scientist convention. It's not a of course it's an illegal guard, but largely it's a science. This is the only global convention which is driven and dictated by the scientists. So science is inbuilt part of it. That means whatever the quotas and the whatever is designed is already has taken into account the scientific argument. For instance, it's not merely a mechanical ceiling for taking this number which must be factored in.
yes, Your Excellency, we submit that RISHMAT in any case has carved out an exception for its indigenous community to take 10 markers a year. And so in case we are able to restrict this taking to animals which are not of a reproductive age, then at least we can mitigate whatever risk that poses in itself. At this stage of critical endangerment, all measures which we can take are only attempts at mitigation, and we hope that we are able to conserve this species.
Just a minute. I would also like to ask you, you were talking about uncertainties of, how much they are using for this vaccination or for creating all these things. If they give you the exact data saying that they are actually using it and how it is going to have the better life of these markers, royal markers, then are you also ready to settle? If the uncertainties are removed on all these aspects?
Your Excellency, we submit that the uncertainty is in the nature of the use of the funds itself.
Yes, that's what I'm saying. If those uncertainties are removed by showing you all the figures and everything, then also you are ready to settle?
Your Excellency, as of now, we are arguing under Article 20G as it relates to the conservation of exhaustible natural resources. But ASTOR also has concerns, moral concerns over the method of the trophy hunt. So the conservation is not the only factor which we are taking into account. So pending instructions, I cannot submit that I would be amenable to settle on this issue, even if they were to propose something that indicates to us that the conservation of the species would be improved by any measures that they would be taking. Sensing no further questions from Your Excellencies and keeping an eye on the time, I will quickly argue that the measure meets the requirements, the measure fails the requirements, of the chapeau. The chapeau prohibits measures which are arbitrary or those which constitute a disguised restriction on international trade. We submit that the measure complies with the chapeau because it is neither arbitrary nor a disguised restriction on international trade. It would be a disguised restriction if it was concealing the pursuit of some fundamentally trade restrictive object. But as we have argued before, Your Excellencies, the objects are related to moral concerns and to the conservation of an exhaustible natural resource. We submit, therefore, that these are purposes fundamentally not concerned with trade. Your Excellency, I seek a minute extension because I realize that one of Your Excellencies had asked me a question about whether the markhor is an exhaustible natural resource, and I had not yet addressed that question. Your Excellency, in the case of US shrimp, and if I may find the exact paragraph number, it was held by the appellate body in US shrimp that the phrase exhaustible natural resource includes living species so long as they are susceptible of extinction. We submit, therefore, that the royal markhor and other species hunted for trophies are an exhaustible natural resource. Now, Your Excellencies, let us be clear about what is at stake here. This is a case about preventing the abuse of protections given under international wildlife law. It is not merely a trade dispute. It is about protecting ASTOR's fundamental right to act on the moral convictions of its citizens and its right to act on its commitment to wildlife conservation. We pray that you find in favor of the applicants.
Thank you. Thank you. You are closing.
Just confirming, am I audible and visible to your excellencies?
Yes.
Much obliged. Just allow me a second. I'm not able to see your excellency. Yeah?
Oh, yeah.
Greetings, your excellencies. This is the statement on behalf of the respondent, the state of Bismarck, represented by Team Court SS10. I shall be taking 21 minutes of the court's time and addressing the first issue, while my co-agent will also be taking 21 minutes and addressing the second issue, reserving 3 minutes for rebuttals. I shall be mirroring the structure of the agent of the applicant, and in line with the same, I have 3 broad submissions to make. First, I submit that the taking that has been carried on or the auctioning off of the hunting rights in and of itself falls within exception 3.5b of the CMS. Secondly, and alternatively, it falls within exception 3.5c of the CMS. And lastly, that it meets all of the preconditions, which is A, being limited and precise in time, B, being precise in content, and lastly, does not disadvantage its species in any manner. With respect to the first submission, I have 2 large sub-arguments to make. First, that Article 3.5b of the CMS must be imparted a wider reading, and secondly, even if a narrower reading is imparted, it still meets the threshold for it being the purpose of propagation and survival of the species. Your Excellencies, under Article 3.5b of the CMS, the taking of an endangered species listed under Appendix 1 is permitted insofar as it is to ensure the propagation and survival of the remainder of the species. We submit that this must be read in line with the objectives of the CMS itself, as per Article 31 of the VCLT, which submits that any treaty, in addition to a textual interpretation, must be read in line with its objectives. Under the preamble of the CMS, the second part reads that the contracting parties are aware that each generation of man holds the resources of the earth for future generation and has an obligation to ensure that this legacy is conserved and where utilized is used wisely. The applicant's contention that the taking must be for the primary purpose of utilizing it for the propagation of the species restricts the ambit of the same, as the objective of the treaty provides that the taking can be done insofar as it is utilized wisely. Which brings me to the second prong of my submission. It is an undisputed fact that the royal marker is specifically susceptible to the to the Mycoplasma capricolum virus, which has a fatality rate of 30 to 40%, which means that if an infection were to spread, we stand to risk a significant portion of this already critically endangered species in and of itself. As such, the funds that are being allocated to ensure the vaccination and conservation effort for the species itself meets the standard and can be adopted with a wider purview. If there are no questions at this end, may I proceed with my submissions?
How much funds are being utilized for that purpose?
Your Excellencies, 15% of the total funds are being allocated towards the same.
According to you, whether they are sufficient or you can increase?
Your Excellencies, we did an estimate calculation of vaccinations for markers, and the same can be found on page 9 of the Respondent Memorial, paragraph 26.
Okay.
Marker and their vaccination specifically.
You cited the preamble to the CMS convention, and the purported the taking, so-called taking, must be used for wisely, for instance. So under the given circumstances, whatever the practice which has been followed, can you put that within the four corners of this wise use under the CMS convention? Does it squarely falls under the convention? Is it a wise use?
Your Excellencies, we submit that it is a wise use for multiple reasons. Firstly, the vaccination for markers as a genus in and of itself, the estimated cost can be found on page 9, paragraph 26 of the Respondent Memorial. We estimate that even at the bare minimum, if the minimum bid starts from 100,000 US dollars, at best the vaccinations are going to take 60,000 US dollars, and yet we've allocated 150,000 for the same, which is more than double the amount that these efforts are likely to take. But secondly, this is a wise use primarily because it is likely to target only older and male markers. The agent for the applicant, specifically the second one, contended that examples such as the rhino one for the case of Namibia may not be translatable because only older males are allowed for killing them. However, markers in and of themselves, and specifically here, are being killed for the size of their horns. It is an established and scientific fact that markers and the sizes of their horns increases with their age, and with each spiral, they tend to gain more and more prominence. Which means that when you're hunting something for a trophy purpose, which is to display it, you want to get the largest trophy possible. In this case as well, you're likely to target older marker males as opposed to younger, more virile males, which means any breeding risks that the applicant may tell you are unlikely to occur. The same has been enunciated in a very extensive study by author P.I. Weinberg and Shagaft Hussain, who are the professors of mammalogy at University of New Mexico and University of Lahore specifically. The title of the paper is The Effect of the Heptica apologies. The effect of the Heptica the effect of the Heptica marker in the state of Turkmenistan, published in the Journal of Mammalogy, which specifically detailed how trophy hunting in Turkmenistan of markers specifically targets older males for this explicit purpose. Does that address Your Excellency's concern?
Yes.
Proceeding further with my submission, we submit that secondly, this is a trophy hunting is well-established method of conservation, specifically in the context of markers. The agent for the applicant stated that they do not dispute that these examples may exist, but they need to be translatable. Insofar as that is the case, we cite to you the Torghar Conservation Project in Pakistan, which specifically centers around the Kashmiri marker, also an endangered species. Under that project, 75% of the funds are being allocated to locals, specifically to make sure that local community is educated and given jobs much like the Dion Ginsu community as tour guides or individuals who can go ahead and ensure that the trophy hunt is successful. The program was started in 1986 and is still operative at this point, and till now has seen an increase in the population from a mere 250 increasing to 3,500 as per the latest census. Yes, Your
Agent,
Excellency.
I have a question for you. This example of the Torgas that you're giving, in this, the trophy hunting is being done by the indigenous community itself. But the elephant in the room here is that the trophy hunting is being auctioned.
Right.
And any protection that comes to those indigenous communities under the ICCPR and the ICESCR comes only because under several general comments, they are following a culture that exists from time immemorial. Now, since 2009, because this auctioning has been happening, that culture itself doesn't exist anymore. The culture has been modified. And once a culture is modified, the culture doesn't even exist. Then that means that these communities can't be doing the taking because they are not doing it in the traditional way wherein someone who wanted to claim adulthood would go and kill the markhor, which would be a religious ceremony. So since that is not happening, how do these communities even have the right to auction for trophy hunting? And we'll get to the viability of the trophy hunting afterwards, but where does the right even exist?
I understand your concern, Your Excellency. In order to address the same, I would like to cite the case of Anderson versus Evans, which was before the Inter-American Committee of Human Rights in 2004. Under this case, the Marca tribe was specifically granted the right to hunt the white-finned shark in the Washington Bay under the Treaty of Niue. However, they had started licensing the right to hunt to other entities who were not the indigenous species, and this right was granted specifically for the sole purpose that they considered the tooth of the shark to be of religious significance. In this case as well, it was held that indigenous communities and any resources that operate under them do possess the right for economic self determination, specifically under ILO 169. Rishmark, in this case, is a party to ILO 169, and we submit that as it's not contested and the agent for the applicant themselves admitted that the marker is a natural resource that operates within them, we submit that the indigenous community does possess the right to transfer it. However, alternatively, we
Agent, the applicant is not a party to the ILO regime, so I don't think we can hear any argument on this basis.
Your Excellency, you can. Under Art, if I may proceed, in the case of Maya indigenous community, again before the Inter-American Committee of Human Rights in the year 2006, it was submitted that ILO 169 and the right for this was extended to Belize. Belize was not a party to ILO 169 at that time. In this case as well, it was held that the right conferred under ILO 169 can be applicable even on a non-party if they encroach upon the rights granted to indigenous communities thereof. Hence, even if the applicant is not a party to ILO 169, they cannot go ahead and intrude upon the obligations that we are supposed to serve as parties to ILO 169. Does that answer Your Excellency's concern?
Are
Do
any
you,
principles of
do you locate your argument, if not party to the convention, do you locate it under the customary law, international law?
Your Excellency,
Has it been
we saw.
elevated to a level where a particular state practice can be placed under customary international law, which will create a legally binding effect?
Your Excellency, we submit that trophy hunting and the rights thereof can be classified as customs because they are prevalent state practice. Multiple states such as Namibia, Turkmenistan, and Vietnam have consistently sanctioned programs of trophy hunting, while some and may not have been by indigenous communities themselves. As such, if the question is regarding trophy hunting itself, it can be established as a state practice. However, in case Your Excellency is still not satisfied, we submit that the essence of the tradition can still be considered to be intact. If Your Excellencies may kindly turn to page 8, paragraph 14 of the record, it is stated that traditionally, when a male member reaches adulthood, he is required to hunt and kill a male royal marker. The meat is shared with the community, and the horns have cultural and religious significance as well. Furthermore, as to within their diplomatic note in and of itself, which can be found on page 13, submitted that this right was granted as a means to ensure subsistence, which they infer to be food, culture, and religious significance. In this case as well, the Dion Ginsu all but pull the trigger. They track the hunt, the meat is still shared with the community, and the horns which were initially used for ceremonial purposes do not serve those purposes anymore. Barring the horns, the process remains exactly the same. So the cultural significance of the same, which is as a right to reach adulthood, remains mostly intact. Thus, we submit that the Dayon Ginsu still possess the right, and the main portion of the same, which is as a right of passage to adulthood, remains unchanged even at this stage. Does that answer Your Excellency's concern? Proceeding further, we state that we argue that the precautionary principle, as argued by the agent for the applicant, may not be applied here. The program itself was sanctioned in the year 2016, and the first concern that was raised by the applicants only came in 2022. Till that time, they were issuing us relevant import permits under CITES, as well as never raised any contentions regarding the trophy hunting. For a period of 6 years, they were absolutely fine with the same continuing. Insofar as that is the case, we rely upon the judgment of Costa Rica versus Nicaragua, in which two concerns were highlighted to assume any principle or precautionary principle specifically under law. First, that there must be a direct link established, and secondly, there must be a risk of transboundary harm. Not only is this claim belated, but there exists no link establishment with respect to the harm that the royal marker has suffered. The Scientific Council of Rishmark, in and of itself, has stated that this limited amount of export is unlikely to impact the population, and we have scientific evidence, as stated earlier as well, that only older male markers are likely to be targeted in this regard. Secondly, we submit that no transboundary harm is likely to occur as well, for the same program has been continuing for 6 years, and the upper limit, which is the cap of 10 markers, remains unchanged. As such, they cannot invoke a principle which they did not invoke prior to the establishment of the program at this belated juncture. Proceeding to the final limb of my submission. Yes, Your Excellency.
Where does this limb of a so-called limitation to raise the precautionary principle come from? Insofar as I know, neither is there any limitation requirement, nor is there any need to establish a purported direct link that you're speaking about, because the precautionary principle in itself is to foster to scientific uncertainty. And these species, by their very nature, are highly migratory. So how can you also say that there will be no transboundary environmental harm as a result?
Your Excellency, our argument is entirely based not on the fact that there's a limitation or an expiry period, but because the activity that is continuing has been continuing for quite some time. It has been 8 years, and the activity of hunting 10 markers has been continuing. It's only in 2022 that they raise a precautionary principle when the end impact of this activity remains unchanged. At this point in time, it is on them to establish that a harm has occurred, because it's no longer a precautionary principle that they're invoking, but they have to prove that a direct harm has actually occurred in order to invoke any principle at this point. If for 8 years there's no evidence that they've presented, there's nothing that ties the fact that there's been a depleting population or even a conventional violation towards the same. This is why we contend that the precautionary principle at this belated juncture cannot be invoked.
Okay, I will have to push you here once more. So the fact that the royal markhor population is declining is not something that necessarily the applicant needs to allege. It's an obligation erga omnes to protect the royal markhors under the CMS and under international environmental law. All states that are parties to the CMS have this obligation, which means that you as the respondent state also has the obligation to conserve the royal markhor whether or not the applicant raises this explicitly. That is indeed the object and purpose, as you were referring to earlier, of the CMS. So the fact that there has been a constant decline in populations of the royal markhor, and the fact that it only exists in the applicant and respondent state, is a fact enough for you to stop any such activities in line with the precautionary principle and not take this hyper-technical view that the applicant didn't raise it 8 years ago.
Your Excellency, it is a matter for the record to clarify that the population remains in decline. For paragraph 1 of the facts itself read that the most current census of the species conducted in 2023 determined that the population consists of 2,200 individuals, and that earlier, due to hunting, habitat loss, and diseases, the range has been decreased. It does not specify a time period that the population has continued to decline due to the trophy hunting or due to the hunting by the Dion Ginsu. As such, unless and until they're able to establish that due to our activities, it has contributed to a significant or even a minimal decline in the population, post that, it remains to be seen as to how they can invoke a precautionary principle at this point. Does that answer Your Excellency's concern?
Can you little extend what the argument which you are trying to make? Is it possible? Have you stumbled upon any other scientific evidence? Because since you have cited some of the published works also, and that is again a different matter about the reliability about the scientific because there are publications and publications. There is a in a way, there is the politics of science also, because there are like the climate change, exemplify the whole thing, that you pack up the whole field with those kind of motivated publications. This is there. So the question is, what do you rely upon? Does it really suit you? So what kind of a factor or what kind of a percentage or thing can you, because like the trails matter principle, if you see that the attribution, that there has to be cause and effect, that is a decline in the number of population, is it can be attributable to the taking, how much, for instance, because like you rightly mentioned, the climatic changes, like the gene pool, kind of some variations could take place, or various developmental projects. There could be accidents which have been happening in all those conservation areas, like the train accidents and whole. So the decline could be like like in Gujarat, for instance, the Asiatic lion, is actually a lot of them dying, for instance. So when you attribute that loss, for instance, how much, or is it merely saying that, well, it's not a, all our concern will be like the, when you talk about across the regulatory process, the approach which is followed is not something which is routine, no, some kind of a smaller thing, but something which is very major, something which can really make a difference. Can you find that factor here, so far as so-called this kind of a argument, so far as the decline in the number is concerned?
Your Excellency, while we do not have a figure or any research to say that so and so percentage is due to the nature of trophy hunting, it is a submission that, much like Your Excellency stated, multiple causes go into the decline of this population. And the same cannot be attributed to a mere 10 male members, which research proves are going to be older male members being trophy hunted in and of themselves. This is why we believe that the trophy hunting program may be allowed to continue, as it does not have a direct link with the significant decline of the population in and of itself. If I may kindly have a minute's extension to go over my second argument.
Yes, please go.
Your Excellency, with respect to the second submission, we submit that alternatively, if Your Excellencies do not place it under exemption 3.5b, 3.5c can also be invoked. Under 3.5c, the taking of a species may be allowed if it is to ensure the subsistence of traditional users. Subsistence in and of itself, while the applicant defined only to be restricted to food and culture, we submit that economic self-subsistence is also something that can be included within the same. Insofar as that is the case, we submit that reliance can be placed upon the Inter-American Convention of Sea Turtles instead of the Whaling Convention. We state this because in Whaling Convention, a very huge distinction was drawn between aboriginal hunting versus it being a commercial activity for the purposes of licensing of whale hunts. However, in the Sea Turtle Convention, the activity for most part is being conducted by the locals, and the eggs and the meat harvested from turtles were being sold. Furthermore, the Sea Turtle Convention also has analogous language to that of the CMS, which reads that it may be permitted if it is to ensure the economic subsistence of traditional users, similar to that of Article 3.5b of the CMS. In this case as well, the Dion Ginsu community have the resource of the royal marker under their purview. Insofar as that is the case, they have the right to determine how to best utilize this resource for the advancement and development of their local community as well, in order to ensure their own subsistence. Thus, we submit that alternatively, it does fall within the ambit of Article 3.5c of the CMS. Are there any questions from Your Excellencies at this point? I sense no concerns, and thus I wrap up my submissions. It was an honor pleading before this bench.
Thank you.
Yeah, thank you.
Yes, the next speaker.
Your Excellency, just to confirm if I'm audible and visible, and permission to proceed with my submissions.
Yes, good, please.
Much obliged, Your Excellency. May it please the bench that I am the agent for the respondents in the second issue put before Your Excellencies, the ban on the importation of the royal markhor hunting trophies, and that it violates conventional international law. It is a submission of the agent that the ban on the trophy hunting violates conventional international law. The same will be proven by the agent based on three arguments. Firstly, that the ban does not meet the requirements of the exception placed under Article 20A of the ARTA. Secondly, that the ban fails to meet the threshold required to clear Article 20G of the ARTA. And lastly, that both of them collectively fail the SHAPI requirements of Article 20 of the ARTA. And thus, with no justifiable exception for a quantitative restriction, the applicants have violated Article 11 of the ARTA by placing a quantitative restriction on the import of trophies via licensing regime. Firstly, to establish an exception, there are 3 steps that are required. That it must correspond to a purpose under Article 20, that it must be sufficiently tailored to the objective under Article 20, and thirdly, that it satisfies the SHAPI. Was there a concern, Your Excellency? Much obliged. An import ban contributes to the issue only when there is a genuine relationship of the ends and means between the objective that is pursued and the measures that are at issue. This is a submission that has been made by the appellate body several times in cases such as Korea beef. Furthermore, in Columbia Textiles, the appellate body explicitly held for an exception of public morals that, firstly, it must be designed to public morals, and secondly, the measure must be necessary to protect such morals. It is this necessity that has not been adequately satisfied in the present case. There were 2 objections that were made out by the applicant in the entire practice of the trophy hunt. The method, which included collecting the urine of the female in what were claimed to be harsh conditions, and secondly, the act of the killing itself. Now, it is pertinent that the agent highlight that when a measure restricts international trade as severely as an import ban does, this is to quote the appellate body in Korea beef at paragraph 7.602, it should only be considered if it is capable of making a material contribution to achieving the stated objectives. In such cases, it is emphasized, the term necessary is closer to indispensable than merely making a contribution. Secondly, as the applicants have also cited incompletely, is the case of ECC. At paragraphs 155, the body held, after the necessity test has been applied, the court must determine whether there are any less restrictive alternatives that the importing country could have implemented in lieu of the import ban. Hence, an analysis of the exception does not stop merely because the measure may contribute to the public morals. For this, the Council makes 2 submissions with regards to the method of the killing before the agent arrives at the act of killing itself. As for the method of the killing,
just give me a second. Can you justify this, your, what I would call it, little extrapolation, saying that, necessity means indispensability, it is not necessary. It's not always necessary. A necessity could be justified from, indispensability, something which always, something remains static, irrespective of your personal opinion or the circumstances. So I think this correlation probably does not appear to be justified. This extrapolation which you sought to do.
Certainly, Your Excellency. However, this is not something that is an extrapolation made by the agent. This is the explicit ruling of the appellate body of the WTO, which it made in the case of Korea beef at paragraph 7.602.
So that's perfectly fine. Like it very well. So far as the precedentiary value itself is concerned, even the International Court of Justice itself is not bound by one of its previous opinions. So there is nothing, there is nothing binding effect so far as the WTO appellate tribunal and other. It can be little considered, factored in. There is nothing automatic. There is nothing binding effect. It can help merely for argumentative purpose of a persuasive value. The international courts of justice own decisions are not having a precedential value. So you can't have a summary, kind of a judgment on that issue.
Certainly, Excellency. However, as per Article 25 of the ARTA that may be present at page 8 of the record, Article 25 subclause 2 states that for the purposes of interpretation of the ARTA, as a subsidiary source of interpretation, judgments of the GATT and the WTO may be brought into the fold. What was sought to be established by the agent was that the exceptions are very strictly defined and that there must be concrete material justification for the availment of these exceptions. The words that were recited were merely a reproduction of the rulings of various appellate bodies. However, as per Article 25 of the ARTA that may be present at page 8 of the record, Article 25 subclause 2 states that for the purposes of interpretation of the ARTA, as a subsidiary source of interpretation, judgments of the GATT and the WTO may be brought into the fold. What was sought to be established by the agent was that the exceptions are very strictly defined and that there must be concrete material justification for the availment of these exceptions. The words that were recited were merely a reproduction of the rulings of various appellate bodies. which are of course the basis for the agent's submission, and of course as sources of interpretation to the ARTA
But
itself.
I think your argument is no, it's not justified. What you're trying, you cannot draw the parallels between two different jurisdictions, different courts and tribunals. They have their own regime, they have their own autonomous standing, etc. You can't say that the something which is permissible or justified under ARTA. The court will have a kind of a International Court of Justice will have the that kind of a little almost little on a higher level, kind of a consideration can be taken into. It is
Certainly, Excellency.
also different regime.
Certainly, Excellency, as the agent themselves stated, these are mainly subsidiary sources of interpretation, and the bench will, of course, come to the findings that Your Excellencies may please. Furthermore, the agent would like to build upon the submissions already made and demonstrate that by the applicant's own submission, they have not fulfilled all of the prerequisites of availing an exception. For instance, to avail an exception on public morals, as the applicants themselves rightly submitted, alternative measures must have been examined. However, in the present case, that has not happened. For this, the agent would like to take Your Excellencies to the CITES. Page 6 of the record, at Annexure A at para 7, reads that both of them are parties to the CITES. Now, the CITES Conference Resolution 16.7 deals specifically with detrimental findings. Article 1A of this resolution provides that a non-detrimental finding by the country of import, in the present case being Aster, for an Appendix 1 or Appendix 2 species in the context of trade is the result of a science-based assessment that verifies, emphasized, whether a proposed export is detrimental to the survival of the species or not. These are all considerations that have already been made by the country that issued the import license, which is Aster. Furthermore, this scheme also provides a way for raising complaints as to the method of the killing. As to the method of the hunt, that is the collection of the urine or the usage of rifles. This perfectly legible forum was already available to the applicants, which they have failed to use. In the words of the applicants themselves, they should have taken alternative and less restrictive measures first. At the same time, as Your Excellencies also rightly pointed out...
Sorry, finish your thought and then I'll ask my question.
Certainly, Excellency. Your Excellencies have very succinctly analyzed this requirement themselves. The agent for the applicant themselves said they would agree to the taking and went on to agree to several alternatives themselves. Then why the import ban was necessary cannot be justified. Simply saying that they have issues with the hunt, but then refusing to go through proper channels to raise concerns with the hunt does not qualify the thresholds of necessity under public morals. The agents themselves give several alternatives, which calls into question the necessity of the ban. Import bans should be implemented as a last resort is an explicit finding of the WTO in several cases, such as Brazil taxation. Less restrictive measures must be explored before an import ban is acted upon. And it is a long-standing principle of international trade law and multilateral trade regimes. Further, Your Excellency had a question?
Yes. So my question is that, this is not the case wherein less restrictive measures could have taken place earlier, when in principle, the question to be addressed is whether or not public morals are being hurt. Now, there have been surveys all over the applicant state, and if I particularly get to the method of killing, the royal markhor is left on the run for 3 hours, half wounded, and then killed. Can it not be killed instantly by, a shotgun? I'm not saying that that's a very pleasant sight to see, but it causes less harm or less trauma to the species concerned. These are the things that baffle me, and this is kind of the point. A moratorium can happen in a COP meeting or can happen through imports through the GATT regime, but the end goal is a moratorium. So I don't see how less restrictive measures can can lead to the public morals not being upheld. And in any case, I think it's perhaps your presumption, because it's not there in the case record, that other means were not tried. Just because we don't see here in the record that the parties did not engage at COP meetings about this issue, it doesn't mean that you can presume that they did not, because at the beginning of the case record, we can see, or even the clarifications, we can see that both parties have consistently appeared before all COP meetings.
Certainly, Excellency.
I think let me little supplement what he has said. I think the very purpose, raison d'être of the whole the issue of taking, for instance, the question remains as to how do you take it. It's like akin to the argument about the death penalty. How less painful a death penalty can be, because there is a huge debate going on what is least painful. If at all you have determined that this is absolutely essential, it fits with tradition, overall goal, etc. So taking, there could be difference between taking and taking. So the convention does not define, but other parameters will always apply. The convention does not stand in isolation, for instance. So for the taking itself is concerned, because not everything go into the black and white, for instance, but we speak about the even the human rights of a person on the death row. Similarly, the animals also have that kind of a right, that kind of a cruelty, or that kind of a that is always across the board, any taking, any killing of animal, always the scales will weigh in favor of the least painful method. If at all you have to take it, it can be justified for scientific purpose or whatever. That has to be justified.
Certainly, Excellency. Thank you so much for both of your questions. What the agent sought to demonstrate was that the burden of proof that was on the respondents in this case, as Article 28 provides, a certain burden of proof, it needs to be established that there were less restrictive alternatives available. By Your Excellency's very own words, they have identified certain alternatives which have not been considered in this case. So it is the submission of the agent in the instant case is purely restricted to the fact that less restrictive measures have not been explored sufficiently in the present case. And until and unless these less restrictive measures have been considered, an import ban cannot be imposed, as it is a very grave distortion on the market. If there are no further questions, the agent would like to move to their second submission, that the SHAPU requirements have not been satisfied.
Agent, sorry to budge you on this again, but in the question that I packaged to you, there was one very simple question in that. Why can't the royal markhor be killed on the spot? Why does it need to be prolonged for 3 hours? It's a simple question. It has a yes/no answer or a very practical one-line answer.
Yeah.
Certainly, Excellency. The agent apologizes for having missed that question. The royal markhor can most certainly be killed on the spot. There is a concept of canned hunts, which is in fact being implemented in the present case. In a canned hunt, an animal has really no chance of escaping, as the applicant's written submissions themselves identify. If a canned hunt was effected in a more careful manner, such as with the use of a crossbow at close range rather than a rifle, because once again, the agent would like to take Your Excellencies to paragraph 16 of the record. Rifles have mostly been used by Astori nationals, while clarification 3 of the record states that the animal continues to suffer for 2 or 3 hours. It is a submission of the agent that there is a possible correlation between the usage of a rifle, which is preferred by Astori nationals, rather than the usage of a crossbow, which was the preferred weapon of the Dione Jinsu community, which could result in a less painful death for the animal, which, as Your Excellency rightly pointed out, animals themselves have the right to life, which deserves to be respected. Your Excellency, all of these alternatives are definitely explorable, and that was the essence of the submission, that they have failed to look at alternatives before going through with an import ban.
Okay, then if you do say that, there was a reason why I asked you this question. If you do say that, then aren't you modifying the culture itself? Because the culture also includes the way in which an animal is killed. if you do kill it on the spot, then it's not a part of the cultural practice of an adolescent going and killing the royal markhor and proclaiming adulthood. This is a practice that's not just prevalent in in the context of royal markhors. There are many species of turtles, like the Pacific leatherback sea turtles, that are killed in areas near Mexico, but they are killed with harpoons. Now, maybe the turtle prolongs, the period of pain and then dies, but that's a part of the culture of the indigenous community. So, how do you balance these two considerations then?
But let me supplement this argument which my colleague Khubchandani has raised. Now even the concerns about adherence, strict compliance or adherence to a particular so-called tradition, custom, religion. These are some of the biggest issues being spoken at the global level. Not only about the human rights, but also about the animal rights, and this is going to be whole issue about international law related to animal protection. So the question is, well, of course the people will take shelter under custom, tradition, faithful compromise. Things have changed. The things have to change under the changing circumstances, for instance, and most of the things people have come around, like couple of, if you draw the parallel, because since we talk about the analogy also, like the whole debate concerning the female genital mutilation. The shelter has been taken under custom, tradition, religion. Now that is under absolutely. There are plenty of things, including the issue. I hope someday, some sensible bench will decide about the marital rape, for instance. The whole argument, the shelter or the whatever the argument. Similarly, this argument, because this is essentially grounded in this whole issue of the tradition of a particular community, indigenous community, tradition. They have been doing it for years, ages together, but the things have changed. The communities have also changed. So in that case, you can't take, so there is nothing in a strict or purest sense. Things have to change, for instance. Is that fine? Is it workable?
Certainly, Excellency, things do have to change, and definitely with the realization of the concepts just colonial hangovers and the reclamation of lost heritage. However, Excellency, in the interest of time, the agent would simply like to reiterate the submissions made by the co-agent in relation to the fact that the tradition is still preserved while the commercial trophy hunt can also go on. And if it may please your Excellencies, the Council would like to move to their second submission.
Yes, please.
Much obliged, Your Excellencies. Your Excellencies, the agent previously drew attention to a principle of trade restrictiveness, as highlighted by the report of the panel in Columbia Textiles at para 5.77. It may be that a measure making a significant contribution is not justified under Article 20 if that measure is highly trade restrictive. Hence, even if there is a significant contribution, it is entirely possible that the measure cannot be taken as an exception because of how restrictive in the nature of its trade it is. It must be noted in the instant case that under the guise of banning the importation of trophies of the Royal Markhor and preserving the Royal Markhor, a complete ban on the importation of hunting trophies has been created. While simultaneously, as paragraph 30 of the record tells us, at page 13, domestic trophy hunting continues to be permissible. This must be read in requirement of the Chapitre of Article 20, which is preventing a disguised restriction of international trade. The sale of trophies in Astor, the market for trophies in Astor still exists, clearly visible by the fact that a single guild with at least 50 members is present, plus undeterminable members. This market has been made inaccessible to all foreign goods. This is a violation of the national treatment principle under WTO laws, as under the garb of public morals, it has sought to foreclose the entire market. Your Excellency, the Council seeks a minute's extension to finish with their submissions.
Okay. Granted.
Much obliged, Your Excellency. Much obliged, Your Excellency. A similar case was observable in China production of audiovisual products. In that case, the Chinese authority had barred foreign companies from distributing media articles in the country, and instead asked them to go through domestic channels. All that did in this case, as was found by the appellate body, was, under the garb of protecting public morals, a general ban has been put into place, which simply cannot be allowed to subsist. This has also been the findings of the appellate body in Brazil retreated tires, the panel in Brazil taxation, and the appellate body in China rare earths, that using an exception, particularly of public morals, to create a general ban on the market is not permissible under law. Lastly, the Council submits that Article 20G exception cannot be availed as it is not as the trophy hunting is not detrimental to the royal markhor. For this, the Council once again takes your excellencies to Conference Resolution 2.11 of the CITES. The importing country itself has found that trophy hunting is not detrimental to the royal markhor. It is extremely pertinent to note this. On record, there is no scientific authority of Astor that has made a conclusion disbarring the conclusion that has impliedly been made 8 years ago. With no material on record to conclude, and especially the fact that the applicant country's own actions would portray that trophy hunting is not detrimental to the conservation of the royal markhor, it cannot be said that the measure is in relation to the conservation of exhaustible natural resources, and hence, combinedly with all of the submissions made by the agent pleads that the honorable bench may find that the ban on the importation of the royal markhor's trophies is in violation of conventional international law and particularly Article 11 of the ATA. If there are no questions, the council would like to take
Yes.
their
Now, any
much obliged, Your Excellency.
rejoinder from the
There is no
time we are having for rejoinder?
Your Excellencies, we have reserved 3 minutes for the rebuttal, if I may proceed with the permission.
Okay, then does Clement want to proceed?
Yes, Your Excellencies.
Proceed.
In the rebuttal, Your Excellencies, I will make one preliminary point on facts, and I will make a point on subsistence use under 35C of the CMS and a point on trade restrictiveness under the trade issue. To begin with, we submit that the respondents have made two errors of fact. For one, they have said that the disease that afflicts the species kills 30 to 40% of its population, whereas the actual figure as per para 18 of the record is 10 to 30%. Moreover, they have relied on scientific evidence that speaks to the Capra falconeri, that is the regular marker, whereas paragraph 1 of the record specifically states that it is not to be confused with the marker in our case, the Capra royale, the royal marker. I state this, Your Excellencies, because their arguments have been on the basis of these facts, and we think that they cannot be allowed to mislead the court. Coming to my first substantive point of rebuttal, that is the arguments they have made about subsistence use under Article 35C. Now, Your Excellencies, they have relied on ILO Convention 169 to argue that they have an obligation to respect the subsistence rights of the Leon-Gitsu community. However, they have cherry-picked the case that they have cited before you to say that one party was party to the ILO 169, whereas the other was not. In that case, the party relied on ILO 169 because it reflected general opinion on what the custom regarding indigenous communities was. But the court was applying a declaration that applied to both the parties, that is the American Declaration on Indigenous Peoples. The court was deciding a treaty that applied to both the parties. And so we submit that they cannot come here and ask the court to enforce obligations upon ATA in respect of a treaty for which it is not a party to. Moreover, there are many ways, Your Excellencies, to respect the subsistence rights of the Leon-Gitsu. The respondents cannot claim that the way to respect these subsistence rights is to violate their obligations under another convention, that is the CMS. There are many ways to enforce the subsistence rights, and this need not be the taking of the animal, which is prohibited under the CMS. We note also, Your Excellencies, that they have not argued the essential proviso requirements, which are required for the taking to fall within the exceptions within 35B. That is, they have given you arguments as to the exceptions, but the proviso is that even if it falls under the exception, the taking must be precise in content, limited in time and space, and not to the disadvantage of the species. They have made no arguments on that front. Finally, Your Excellencies, I turn to the trade issue, where the respondents have contended that we have not given you alternative measures. However, as we had noted earlier, it is a holistic assessment of necessity. The respondents made no reference to the goal of our object, the goal of the measure, which was to curb the involvement of Astro's nationals in foreign trophy hunting. In speaking of less trade restrictive measures, they must always link it back to the goal and see whether these less restrictive measures will in fact fulfill that goal. If they fail to do so, they cannot disprove that the measure is not necessary. May it please this court.
Thank you. What about respondent? Whether they have also reserved the time for repeat anything? No, no?
Your Excellencies, the respondents reserve 3 minutes for rebuttal.
Okay. So what you would like to say?
Much obliged, Your Excellency. It would like to be made apparent to Your Excellencies that the respondents have in no case misled the court. The provisional justification, the proviso requirement is justified under the CMS as it is limited in time and place. It is limited to the members of the Daini Jinsu community that further than auction of that right. The place is restricted to the Daino Jinsu communities reserves in apologies to the Daini Jinsu communities reserves in the country of Rishmat. Furthermore, it is not detrimental to the species in the own finding of the applicants, as was strenuously highlighted by this agent in their submissions. Before an import permit is given out under CITES, the scientific authority of the importing country must also make an observation that the activity of the import is not detrimental to the species. This is present under Article 3, Paragraph 1, Subclause A. Hence, they themselves have found that this exercise of trophy hunting is not detrimental to the species, yet they now come and claim the contrary. Furthermore, ILO Article 169 used to infer to the declaration. The preliminary objection was raised by Belize, the country that was not party to ILO, on using ILO 169 to interpret the same. But the same was permitted, it is emphasized, due to the analogous language, and it was specifically held in paragraph 18 of the judgment that merely because a state is non-party to the ILO 169 does not imply that it may stop or in any manner restrict the state that is party to the same for fulfilling the obligations under ILO 169. They have made a material the applicants have made a material misrepresentation to the court. Lastly, the applicants have likely pointed out that the goal of the measure is material. However, in the present case, the goal of the measure has then been distorted to apply a market distortion that goes beyond the goal of the measure and in turn becomes a disguised restriction on trade. The agent would like to highlight the case of Brazil retreated tires. The case related to an exception availed under Article 20, Clause B. The appellate body in that case explicitly went on to find that while the measure was justified, the way in which the justification of the measure was implemented was found to be discriminatory in nature. In that case, owing to health concerns, the country of Brazil had banned the import of retreated tires into the country from certain countries, while its own market for retreated tires went on unchallenged, as well as also for some countries with which it had a regional trade agreement. In the instant case, the same has happened. The market has been selectively closed off to certain countries. In this case, all countries that import trophies to Astral, while the market has been kept open for the domestic industry. Lastly, it was not said by the agents for the respondent that the two species are the same, the Markhor and the Royal Markhor. They are different, but they are as close an example as can get, versus the applicant that ended up relying on lions. In fact, the submission of the respondents was more accurate, as there is some genetic similarities between the Markhor and the Royal Markhor, rather than the lions in the Royal Markhor that were relied on by the applicants. Much obliged, Your Excellency.
Thank you. Thank you to all the participants. Yes.
Thank you for the rounds. I request the participants to exit the meeting while the judges give a scoring, and we'll call you back once the scoring is done. Thank you.
Thank you so much.
I hope all the judges have the scoring sheets with you readily available. And judges
whether any of you us want to discuss it, or we should do it individually. What is to be done? All the respected members of the panel. What is to be done?
I think we can do it. Yeah, on our own. I think maybe. Yeah, we already had the discussions more than enough.
Okay.
We already shot the upper limit of time. Already it's 3:30, isn't it?
Yes.
So
Yes. Yes.
when have you scheduled the valedictory session?
Oh, so it's from 4 o'clock.
4 o'clock. Okay.
Yeah. We'll be having the valedictory in about 15 minutes, so that's about the time we have left.
तीन चार पाँच छः सात
So Abhikya, what is the proceedings? Hello. Where are the team members?
So we are waiting for the team member to join. Kindly allow us few minutes, sir.
Yeah. But keep updating us, na? So Dr. Nilratna, when did you retire from MOEF?
2012.
2012. I see. Okay. So we normally divide that era between pre Pradipto Ghosh era, Pradipto Ghosh era and post Pradipto Ghosh era.
Yeah, it was more after, I think, after Pradipta Ghosh.
Yeah.
He was there for some
Yeah.
time when I was there.
Yeah.
Then
Why
Mr.
I
Sarma came.
mentioned, because that was the qualitative change which came about, because he was like a scholarly, always in a scholarly mold, always on the job. He'll understand the subject, take up the things. Some
Exactly.
other secretaries did not have that kind of a background. Obviously, they didn't have background.
Yeah, in my time, Mr. Sharma was there. So he was very, very good that way.
Okay. Meenakshi Gupta, she was there, no?
Meenakshi Gupta was for
Meena Gupta.
very
Meena
small
Gupta,
time.
yeah.
She was also there,
Yeah.
but very small time.
Yeah, then I think it didn't have that kind of a sharpness, the secretaries who came up subsequently, although they are
Exactly.
good people, but what you expect, in terms of India's negotiating positions, and because we waged many battles, on climate front, on like
Yeah.
even plenty of other things, global public goods, forestry,
Hello everyone, I am Manashwini Samal, joined by my colleague Ara Mishra on behalf of the whole Moot Court Committee of MNLU Nagpur, extend our best wishes to everyone present here. It gives us immense pleasure to welcome you all on this day that marks the successful culmination of the Surana and Surana SAARC Regional South rounds of the 29th Stetson Environmental Moot Court Competition 2025. We're extremely honored to have with us the dignitaries, honorable judges, members of the bar, academia, students, and the invited guests.
I would like to take this moment to extend our warm welcome to the chief guest of the ceremony, Her Ladyship, Honorable Srimati Justice Shalini Joshi Phansalkar, former Judge, High Court of Bombay, and our special guest of the honor, His Lordship, Honorable Shri Justice M.L. Gilani, former Judge, High Court of Bombay, Professor Dr. Bharat H. Desai, Sir, Director, Institute for Advanced Studies in International Law and Diplomacy, Dr. B.P. Neelaratna, former Joint Secretary to the Ministry of Environment and Forest, Government of India, Advocate, Supreme Court of India, Legal Defence Firm, New Delhi, Mr. Mohit Kupchandani, International Disputes Resolution Attorney, Mr. Preetam Surana, National Law University, Nagpur, Mr. Vivek B. Gawane, District Judge and Registrar, MNLU, Nagpur, participants, faculty members, and one and all present here.
The Stetson Moot, organized by the Institute of Biodiversity, Law and Policy at Stetson University, stands as the premier global competition on international environmental law, focusing on critical issues like conservation and sustainability. Established in 1997 with international rounds introduced in 2001, this prestigious moot simulates proceedings before the International Court of Justice, attracting participation from leading law schools worldwide. With its emphasis on legal expertise and collaboration, the Stetson Moot continues to inspire and advance the study of environmental law on a global scale. We would like to take this moment to extend our heartfelt gratitude towards the dignitaries to have graced this occasion, our respected judges of the Moot Court competitions, university authorities, faculty advisors, the students, student members of the Moot Court Committee, and the participants, without whose relentless efforts this competition would not have transpired into a success.
As we commence the valedictory ceremony, may I now request the convener of the Moot Court Committee, Mr. Soham Kale, whose leadership has been of immense value to us, to present the event report for Surana and Surana SAARC Regional South Rounds of the 29th Stetson International Environment Law Moot Court Competition 2025.
Very good evening to everyone present here. On behalf of the Moot Court Committee of Maharashtra National Law University, Nagpur, and the entire organizing team of the Surana and Surana SAARC Regional South Rounds of the 29th Stetson International Environmental Moot Court Competition 2025, in association with Surana and Surana International Attorneys, I, Soham Kale, convener of the Moot Court Committee, am honored to present the event report. The Moot Court Committee of MNLU Nagpur envisions fostering a culture of academic excellence, legal advocacy, and professional skill development among students. It strives to promote legal education, enhance mooting skills, and inspire critical thinking through moot court competitions. The Moot Court Committee also emphasizes leadership, teamwork, and ethical standards while providing students with opportunities for global exposure and professional growth. Events like the Stetson International Environmental Moot Court Competition exemplify this vision, showcasing the university's commitment to creating confident, competent, and socially responsible legal professionals. In fact, with the invaluable experience gained from organizing this prestigious competition with the help and guidance of Surana and Surana International Attorneys, the Moot Court Committee is now co-event the MNLU Nagpur National Technology Law Moot 2025 with even greater efficiency and innovation in the last week of March 2025. Moving forward, the regional qualifiers were conducted from January 17th to 19th, 2025. A total of 12 universities registered and all 12 teams participated in the virtual oral rounds, competing fiercely for the coveted winner's title. This year's moot proposition addresses the legality of trophy hunting practices and the associated import restrictions under the international law, focusing on conservation, subsistence use, and trade obligations. The competition officially commenced on January 17th with an inaugural ceremony graced by the presence of Professor Dr. Vijendra Kumar, Honorable Vice Chancellor, Maharashtra National Law University, Nagpur, and Mr. Preetam Surana, Partner, Dispute Resolution, and Head of Academic Initiatives, Surana and Surana International Attorneys. During his address, Honorable Vice Chancellor expressed his gratitude to Mr. Pritam Surana for selecting MNLU Nagpur to host the South rounds of the 29th Annual Stetson International Environmental Moot Court Competition and for providing the university with this prestigious opportunity. He also highlighted the eco-friendly initiatives of the MNLU Nagpur campus, emphasizing the campus lake that meets most of the university's water needs. Mr. Pritam Surana then addressed the gathering, sharing valuable insights and expressing interest in hosting a future on-campus competition at MNLU Nagpur. We are eagerly Johnson Christie, Manager, Special Projects, Academic Initiatives and Dispute Resolution Practice, Surana and Surana International Attorneys conducted explaining the process of competition code generation, the draw of lots and the memorial exchange. Moving forward, on January 18th, the second day of the competition, in 2 preliminary oral rounds, judged by a panel of 12 to 15 esteemed judges. The top 8 teams advanced to the quarterfinal rounds, which were also held on the same day. The third and 19th, that is today, saw 4 teams, namely Nalsa University of Law, Hyderabad, O.P. Jindal Global University, Soni Law College, Pune, and Maharashtra National Law University, Mumbai, competing in the semi-final rounds. The distinguished judges for these rounds included Honorable District Judge Bhushan Shirsagar, Judge, District and Session Courts, Pune, Professor Siti Hafsia Idris, Environmental Law Lecturer and Director of Community Network Center at University Technology Mara, Mr. Prayang Jain, Senior Program Associate, SED Fund, Ms. Pooja Chatterjee, Partner, Kings Taban Kasiwa, Advocates and Attorneys, Mr. Abhishek Jain, Associate, Cyril Amarchand Mangaldas, and Law at Stetson University. The top 2 teams proceeded to the final rounds, which were judged by a distinguished 5-member bench comprising of Honorable Dr. Srimati Justice Shalini Fansalkar Joshi, former Judge, High Court of Bombay, bench at Nagpur, Honorable Shri Justice M.N. Gilani, former Judge, High Court of Bombay, bench at Nagpur, Professor Dr. Bharat H. Desai, Director, Institute for Advanced Studies in International Law and Diplomacy, former Chairperson and Professor of International Law at Jawaharlal Nehru University, New Delhi, Advocate B.P. Nilaratna, Managing Partner, Enviro Legal Defense Firm, and Mr. Mohit Khub Chandani, Visiting Foreign Lawyer, Wilmerhall. After a rigorous evaluation of the intense oral rounds, the results will be announced shortly, reaching the successful SAARC Regional South Rounds International Environmental Moot Court Competition 2025 hosted by MNLU Nagpur. Thank you.
Thank you, Soham. This event could not have been possible without the leadership of Professor Dr. Vijendra Kumar, Honorable Vice Chancellor, Sir, Telangana. Before joining our university as its founding Vice Chancellor, he also held the office of Vice Chancellor at the National Law University and Judicial Academy, Assam, and position of Registrar at Nalsa University of Law, Hyderabad. An astute academician and research scholar, he has numerous publications to his credit, including more than 70 research articles published in reputed law journals on Hindu law, research methodology, and legal education, in addition to its contribution in several book reviews and papers in numerous books. May we now request our Honorable Vice Chancellor, Professor Dr. Vijendra Kumar, to kindly deliver the welcome address.
Thank you very much. Yeah, Honorable Srimati Justice Dr. Shalini Joshi Pansalkar, the former Judge, High Court of Bombay, bench at Nagpur. Honorable Sri Justice N.M. Gilani Saab, former Judge, High Court of Bombay, bench at Nagpur. Both of them had been my well-wishers since 2016 when we started this university in civil line at Jyoti. Professor Bharat Desai ji, Dr. B.P. Nilaratna, Advocate Mohit Khub Chandani Saab as a special guest of honor. Mr. Pritam Surana ji had been with us last 3 days. My faculty colleagues, my registrar, Mr. Vivek Gawani, faculty advisor of the Moot Court Committee, Dr. Divita Page, Professor Sanya Agarwal, Soham, along with his team, the volunteers, all the participants of 29th Annual Stetson International Environmental Law Moot Court Competition, SAARC, because through these 2 arguments from different, they carry the cause of justice for men underprivileged. So the two teams which fought in the final. I salute them for administration, their library staff, their sources to the best of their capabilities. And these three members, or maybe a lot more than one or two, they put their efforts tirelessly. We appreciate. With these few words, I wish them a good luck. I also wish them to represent this region to the globe, and I'm sure they will take care not only their institutions but the flag of Surana and Surana and MNLU Nagpur also. With these few words, I stop myself here. Colleagues in the valedictory programs, my guests, and my judges of the final round. Thank you very much. Namaskar.
Thank you, sir, for your constant guidance and support. We have with us Mr. Preetham Surana, Partner Dispute Resolution and Head of Academic Initiatives at Surana and Surana International Attorneys. Sir is a dedicated leader who has been a former member of CIISR Task Force on International Linkages, CIISR Working Group on Infra Finance, CIISR Family Business Subcommittee, CIISR MSME Subcom Committee, and Madras Chamber of Commerce and Industry MSME Subcommittee. Since 1971, Surana and Surana International Attorneys has been recognized as the first choice for legal services in South India, earning accolades from clients, institutions, and global publications like Chambers and Partners, Asia Pacific 500, and Business Today. With ISO certifications, a global network, and leadership roles in major organizations, the firm owes its success to the dedication of key figures like Preetham Surana, whose efforts have been instrumental in its growth and reputation. We would now like to invite Mr. Preetham Surana, Partner Dispute Resolution and Head of Academic Initiatives at Surana and Surana International Attorneys, to kindly address this gathering and enlighten the students with his words.
Thank you. My greetings, Honorable Justice Dr. Shalini Joshi, former Judge, Bombay High Court, Honorable Justice Mr. M.N. Gilani, former Judge, Bombay High Court, Professor Dr. Vijender Kumar, Vice Chancellor, Maharashtra National Law University, Professor Dr. Bharat Desai, the Jawaharlal Nehru Chair in International Environment Law at the Jawaharlal Nehru University, New Delhi, Dr. B.P. Neil Ratna, Senior Legal Advisor at the Environment Law and Development Foundation and former Joint Secretary, Ministry of Environment and Forest, Government of India, Mr. Mohit Khubchandani, Registrar Mr. Vivek B. Gawani, Faculty Advisors Mr. Divita, Dr. Shilpa Jain, Faculty Coordinators, Moot Court Conveners, Moot Court Committee members, staff, students, and my dear participants. It is my privilege and honor to address this august gathering as a representative of the law firm. While our visionary founder, Mr. P.S. Surana, and our present CEO and managing partner, Dr. Vinod Surana, an ecosystem of an experiential learning through the introduction of moot courts in the country nearly 3 decades ago, our endeavor has been to provide other opportunities through our academic initiatives platform besides the essay competitions, arbitral award, and judgment writing competitions. Lately, we have been feeling the need of doing something to address the issues of living in the digital age. In today's digital age, the technology is revolutionizing every aspect of our lives. However, our legal frameworks are struggling to keep pace. As we navigate the complexities of artificial intelligence, blockchain, cybersecurity, and more, it is clear that the law must evolve to address these new challenges. There is an inherent need to bridge this gap. To address this critical need, we have launched an innovative competition called Law and Policy in association with the Indian Institute of Technology, Madras, that brings together students of law and science to develop solutions for the most pressing issues in law. This initiative invites students from diverse backgrounds to collaborate.
Very fortunate to win the Best Memorials Award. And that led to and pay as a gratitude to the Stetson Moot. And since then, I've been involved in public international law, particularly international environmental law, both through my academic work and my practice. And I also had the great fortune of working at the ICJ for a period of time. So all of this to say to the students that, as Professor Vijender Kumar also mentioned, that there is no better exercise than participating in these moot court competitions when you're a student, because you can be writing publications all your life, even after you have graduated from law school. But this is the only time you can actually participate in a moot court competition. And that's what I tell all students. So with these words, again, I cannot emphasize enough how honored I am to share the panel with two former judges of the Bombay High Court, Professor Desai, about whom I've read so much and followed him so much, and equally Dr. Neil Ratna. And me being on this bench is only a testament to the legacy that Stetson leaves on the lives of many people like me, and I wish all the best to the students, and my gratitude to the organizers for having me today.
We're very grateful for those inspiring words, sir. Next, we wholeheartedly welcome Dr. B.P. Neil Ratna, former Joint Secretary to the Ministry of India and Advocate Supreme Court of India. We're deeply honored to welcome Dr. Neil Ratna, a luminary whose unparalleled expertise spans the realms of law, science, and administration. Dr. Neil Ratna's academic journey is nothing short of extraordinary. He holds a law degree from the University of Delhi, a master's in physics from IIT Kanpur, a PhD in physics from the University of Leeds, UK, and a doctorate in literature in economics. With an illustrious career spanning over 34 years of distinguished administrative and scientific contribution, Dr. Neil Ratna has left an indelible mark as a former Joint Secretary to the Ministry of Environment and Forest, Government of India. His global influence is evident through his representation of India at various international forums, including Montreal Protocol meetings, where he played a pivotal role in shaping global environmental policies. As the national focal point for ozone, the Montreal Protocol, mangroves, and coral reefs, Dr. Neil Ratna has been at the forefront of driving impactful environmental initiatives. Adding to his illustrious portfolio, Dr. Neil Ratna has also served as the National Project Director for UNDP GEF project on medicinal plants, a role in which he championed that cause of diversity and sustainable development. Dr. Neil Ratna is also a seasoned legal professional, having advocated at the Supreme Court for over a decade. As the managing partner of Enviro Legal and Defense Firm New Delhi, he continues to blend in his legal acumen with his unwavering commitment to environmental sustainability. May I now request Dr. B.P. Neil Ratna to kindly address this gathering.
Thank you, ma'am, saying so many words for me. Honorable Vice Chancellor Professor Vijender Kumar ji, Pritam Surana ji, distinguished judges, fellow judges of this competition, members of Moot Court Committee, faculty members of the university, and the competitors. First of all, I would like to express my gratitude to the committee for inviting me to this final rounds of competition and the valedictory function. I would also like to say in advance congratulations to the team for which the result are yet to come. I'm sure that our fellow judges, they have given marks and they have judged the best competitor in this round of competition. The subject related to this substance use and trophy hunting of the royal markers arising out of the dispute between two sovereign states, Bismarck and Asters. As you are aware that royal markers is a critically endangered large wild goat that is native to several countries. In fact, it used to be found in 6 countries, but now it is only found in Aster and Bismarck. It is also timely subject because last year, that is on 2nd of May 2024, the United Nations General Assembly has declared 24th May as the International Day of the Markers. So it is very timely, this subject, I'm sure, and it will be very helpful for all of us to know about this dispute and its resolution. Well, ultimately, it relates to the conservation of the markers. It is really a problem everywhere. In most other countries, I'm not only limiting to the royal marker, but I'm talking the markers in general, because ultimately the name comes from Pakistan, and the marker is the national animal of Pakistan. So, in fact, this competition definitely has given a great insight of the problem, its legal issues, especially from the point of view of the international law. And after this competition, I'm sure the students will also be benefited from this kind of exercise. I would like to express my special thanks to Surana ji, because ultimately he's the man behind all these competitions. So my congratulations to him also. And with these words, once again, to express my thanks and gratitude to the members of the Moot Committee. Thank you very much.
We are highly obliged for those invaluable words of wisdom, sir. It is an honor and privilege to introduce Professor Dr. Bharat H. Desai, sir, one of the most distinguished scholars in the field of international law and diplomacy. Currently serving as the director of the Institute for Advanced Studies in International Law and Diplomacy, Professor Desai's illustrious career has been marked by unparalleled contributions to academia, policy making, and global governance. Professor Desai is former chairperson of the Jawaharlal Nehru Chair and professor of international law at Center for International Legal Studies, School of International Studies, Jawaharlal Nehru University, New Delhi. He has been the editor-in-chief of Environmental Policy and Law, IOS Press Amsterdam, contributing significantly to shaping global discourses on environmental governance and policy. His involvement in multilateral negotiations as part of India's official delegation has cemented his status as a global authority in international law. Professor Desai has authored 14 books, 106 plus research articles, and 60 plus influential blog articles, making transformative contributions to global discussions on the reform of international institutions. His visionary ideas include the establishment of specialized agency for environment, the repurposing of the UN Trusteeship Council, the creation of International Environmental Cell, and the advancement of international environmental governance, all aimed at ensuring a sustainable planetary future. His expertise has been sought by esteemed organizations such as Union Ministries of External Affairs, Environment, Forest, and Climate Change, the World Bank, the World Conservation Union, and the Asian Development Bank. Professor Desai's profound ideas on foreign policy, national security, and university reforms have reached the highest echelons of Indian governance, including one-on-one presentations to Prime Minister Narendra Modi, his Principal Secretary, and the Prime Minister's office. May I please request Professor Bharat H. Desai, sir, to share his insights with the gathering.
Well, yeah, thank you very much for this more than a generous introduction. It's a pleasure for me to be here. This very prestigious Stetson Moot Court competition organized by Maharashtra National Law School. I had again a privilege of being a judge in the final round of the Stetson organized by O.P. Jindal, I think 2 to 3 years ago. So this is again I really appreciate the kind of the theme which is chosen. I thank my co-panelists who were part of the team, the judges team in the final round. Justice Jilani, Justice Joshi, Mohit Kupchandani, and Dr. Nilaratna. I really enjoyed the very special effort, audacious effort, which was made by these both on the side of the applicants as well as the respondents. I admire the sheer effort which has really gone into the and the kind of the zeal with which the different contestants they stood their ground, faced the arguments, put forward the best defense of what this is exactly what advocacy means. And irrespective of the outcome, I think that will be probably shortly announced. Now I have few because the time is running out, so I'll just have a few quick comments to make. First is I really admire the solid support provided by Surana and Surana, especially Ms. Pritam Surana is here. I think my concern as a teacher, as a scholar, in the field of international law, my concern will be little doing it a little larger than this, because I'm not run of the mill. I don't, I always try to, even when I have a one-on-one meeting with the Prime Minister of India, I talk to him upfront, and remarkably, you can see if the Prime Minister of the country speaks language of international law, I think this is, this brings about the change. You can see when I asked him, I said, I want you to speak the language of international law. He's a smart person, fast learner. So he speaks language of international law. His foreign minister speaks, the defense minister speaks across the board. This is unheard of. This has never happened in the last many decades, where, because earlier they used to speak about beating around the bush, rule-based world order, that is gone. The Minister of External Affairs and this highest political, they explicitly speak about, relevance of international law, commitment to international law. This brings about a change when India wants to be on the global high table. So it will make a little difference. Now, my specific, I would say I have made a lot of other efforts so far as, but today is not the time to go into that argument. Taking international law seriously, making international work, including right up to the surgical strikes committed, carried out by India. I have spoken upfront. I said, आपको किसी को मारना भी है तो तरीके से मारना पड़ेगा. You have to create a legal brief with the ground, the justification. You can't do that otherwise. So law has to be behind those things. Now, as far as the couple of things, because this focus of this Moot Court competition is international environmental law, since I have been trying to grapple with sitting 12,000 kilometers away from the decision-making center of the world at United Nations and many of these Ivy League universities in the United States. I really, I don't need to spell out what I have, grappled with. But it's amazing thing. Last 4 or 5 years, I dabbled with couple of almost 70 to 80 outstanding scholars from all parts of the world, because I try to change the mosaic of this entire international environmental law and institution building process. So there are, as I said, I uncovered a lot of hidden problems which are there. And as you can see, why it is so important, and this kind of a Moot Court competition really holds great, because this places things under scanner, because the world is really going through a very difficult phase. As I said, it's facing a planetary kind of a crisis. I've written an umpteen number of things. If somebody is interested, I can really provide through my journal, The Planetary Future. The Secretary is talking about the planetary crisis. And now, amazing thing, going back to the beginning, right from the Stockholm conference, 50 years plus, everybody is groping in the dark. What precisely went wrong? You went on doing that gigantic global regulatory approach to improve the global environment. It has continued to deteriorate. And I think probably it was a shocker when at the 2022 Stockholm plus Free conference, the executive director of UNEP, she said upfront that if look at how the things work, that if Olof Palme was alive and if Indira Gandhi was alive and if they enter into the Stockholm conference hall today, what face we will show to them, what we will tell them that what we did in 50 years. That means we were running, but we were running in the same place. If in spite of all those multi-trillions of dollars, the time, the effort, the global conventions, name it, and they are there, and yet if the global environment continue to deteriorate, it's really a matter of great worry. And that is exactly the issue which I went into. I said, what went wrong? Let us discover that part. And I've been doing very audacious. I'm just mentioning. I'm not, exaggerating those things. But I said, I put aside a little focus on the women scholars. I said, if women take a look at the global environmental problematic, does it look different? And people were shocked. So there are a lot of those issues, including the issue of the ideating on the planetary future, for instance. What will it take? And probably you will, this is exactly the probably a possible focus could be there in the future moot court competitions. Some of the issues and ideas which have really gone. I went to, Dr. Swaminathan when he was alive. I went on, I requested him, I said, I want your art, and till 2 years ago, he said, Bharat, I'm not keeping well. Let me recover. I want to contribute to you. At the age of 95, 96, he kept on promising. But, unfortunately, I couldn't have his contribution. I reached out to Dr. Karan Singh, who is 94. He's 94. And he wrote an article for me, The Planetary Future, some reflections, because you are so desperate to fetch in ideas as to what direction we are heading. It's not a merely question of making the career, earning money, passing time, because the time has run out. Very rapidly depleting time, So here are the things you are literally groping in the dark. Question is, who will bail the cat?
Okay. It is a net problem, I think. Soham, just check the connectivity, please.
Yes, sir. Yes, sir. Give me a minute, sir.
The issue. That means this whole issue has become literally rudderless. And I thought that so far from the question of ideas are concerned, probably a moot court competition like this can really, little bit, peel the layers and try to put on this. This will provide a good amount of exposure to it. Now, other issue which Pitam Surana mentioned, is about the technology, and this really holds the key. Let me mention how significant it could be. For instance, even with reference as especially environmental issue, like probably many people may not be aware that in the 22nd of September 2024, when the Summit of the Future adopted the Pact for the Future, there is a special annexure on Global Digital Compact. Global Digital Compact. Imagine, although it's a very short kind of instrument, 5-page instrument, I have analyzed and I can provide the copy. Pact for the Future and future of the planet. A preliminary stock taking, for instance. So the technology will hold the key as we move forward, right, from climate change to plenty of those issues. And so the digital. So what will it bring about? The digital age, for instance. These are the new challenges which we need to really place them under scanner. Because the more you go tech savvy, the more problems. What lies in store, for instance, for the humankind, we don't know. And probably from the issue challenges from this part of the world, from the global south, because the global north, even if they will face many of the problems, they have the resilience, the capacity, the funding resources. From the global south, the situation is survival. So how we will cope up? Because you don't know the hidden risk which are there, like the way in which the other issue probably could be also is a data mining. Huge amount of data is going, like the government of India is at the highest level is considering that issue about can we do the gatekeeping? Can we put this
Again,
giants, under the scanner that
connectivity problem again. I feel there is a connectivity issue, Sohan.
I don't think it's an issue
Took,
from our end.
Not
some
our
15
end,
years
sir.
ago. Just find up in one of the top law firms in Ahmedabad. I went, and the fellow told me that in Ahmedabad you don't ask questions about teaching and research. All that counts in Ahmedabad is money. I said, fine, thank you very much, and I came back. So I really admire that the Surana is taking the initiative, providing this kind of a backbone support for a very significant moot court competition like Stetson. And really, I appreciate and commend efforts of Surana, Maharashtra National Law University, our Fisty Vice Chancellor, my colleague, Vijendra Kumar, and all the faculty members, the team, the dynamic, all those people who have really done this all round, and all the participant teams. Now, I really congratulate all of you and wish you all the best. Thank you.
Thank you so much, sir, for those invaluable words. We are deeply obliged. Now, moving on, we are profoundly honored to welcome His Lordship, Honorable Shri Justice M.H. Gilani, a venerable legal luminary whose remarkable career reflects decades of unwavering dedication to the judiciary, justice, and public service. Hailing from a humble agricultural background in Yavatmal, Maharashtra, His Lordship's journey exemplifies the power of perseverance and intellect. After earning a BSc and LLB, His Lordship embarked on a legal career in 1975, enrolling as an advocate and quickly distinguishing himself as a promising legal mind. His Lordship joined the judiciary in 1980, a decision that would herald an era of judicial brilliance and administrative excellence. Throughout an illustrious career, His Lordship has served with distinction in key judicial and administrative roles, leaving an indelible mark on the legal landscape of Maharashtra and beyond. Among the pivotal positions he has held are Chief Metropolitan Magistrate, Special Judge under TADA and NDPS Acts, and Principal District and Sessions Judge Nagpur. His Lordship's expertise extended to the administrative excellence as well, serving as Principal Secretary, Legal Remembrancer, and Registrar General of the Bombay High Court, where he contributed to the efficient functioning of the judiciary. His Lordship was elevated to the High Court of Bombay, where his tenure was marked by groundbreaking judgments, judicial foresight, and a profound sense of fairness. His Lordship retired in January 2013, concluding a stellar career that has inspired countless members of the legal fraternity. It is with the highest respect and admiration that we extend a heartfelt welcome to Honorable Shri Justice M.N. Gilani. Thank you for accepting our invitation today, sir, to grace this occasion.
We are truly privileged and honored to have as a chief guest of today's ceremony Her Ladyship Honorable Justice Srimati Shalini Joshi Phansalkar, former Judge of High Court of Bombay. Her Ladyship is a trailblazer in the legal and judicial arena, renowned for her exceptional intellect, compassionate leadership, and over 31 years of distinguished service to the judiciary and the society. Her Ladyship's illustrious career has been marked by several pivotal roles, including serving as the Principal Judge of the City Civil and Sessions Court, Mumbai, the Registrar General of the Bombay High Court, and the judge in specialized courts addressing critical issues such as women's rights and juvenile justice. Her expertise in these sensitive and vital areas reflect her deep commitment to upholding justice and fostering societal well-being. A passionate academician and thought leader, Her Ladyship holds a doctorate of law from Pune University, with her thesis focusing on pressing subjects of child sexual abuse, a socio-legal perspective. As a British scholar in gender and law and a Commonwealth Judicial Education Fellow in Canada, Her Ladyship has gained global recognition for her groundbreaking work in advancing judicial thought and gender justice. Her Ladyship has also served as the officiating director of the Maharashtra Judicial Academy, where Her Ladyship played an instrumental role in shaping the future of the judiciary. Even after her illustrious tenure on the bench, Her Ladyship continues to enrich the legal landscape through her active contribution in academia, arbitration, mediation, and legal consultations. It is an absolute honor to welcome Honorable Srimati Justice Shalini Joshi Phansalkar as the Chief Guest of today's event. May we now request Honorable Srimati Justice Shalini Joshi Fansalkar, to kindly grace us with her kind and inspiring words.
Thank you so much. Dr. Vijayendra Kumar, esteemed Vice Chancellor of Maharashtra National Law University, Nagpur. Mr. Pritam Surana, from the organizers Surana and Surana. My senior colleague on the real bench and today's bench also, Justice Mr. M.N. Gilani. The other esteemed and expert members in the field of environment and international law, Mr. Bharat Desai, Mr. Neil Ratna, and the living example, success story of this moot court competition, Mr. Khubchandani. It was all the faculty members, the registrar of the National Law, Maharashtra National Law University, Mr. Vivek Gavhane, all the faculty members, then Soham Kale, the convener and other members of the moot court committee, the dear participants. It was my immense pleasure to preside over the bench of 5 judges and to be, judging the competition, which as a judge also I had no occasion, especially in the environmental law. We rarely get across the cases of international environmental law, and therefore it was a intellectually stimulating exercise for me also to be part of this competition. And I really enjoyed being on the bench, especially when I had the experts, distinguished members on the bench who were able to grill the participants on this particular subject, to which I might not have been exposed, but for this moot court competition. And therefore, I am really thankful to give me this an opportunity to be part of this competition. I must congratulate the organizers, Mr. Surana and Surana, for selecting this subject and having such a long legacy of conducting these competitions, of which I have heard a lot. It is really interesting, and it is really, exposing the law students to such a new era and emerging era of the litigation, where they can go from places to places, and that's really a matter of commendable. Today's exercise, moot court competition, which was prepared for, that was also very well balanced. Both parties were having equal opportunity to argue the case. Equal points in their favor, and balance could be tilted at one stage from this side to another side. And I must congratulate all the participants. They have done very well, extremely well. To be grilled and to be able to answer the queries raised by the experts in the field. Everyone, when I was listening to their introductions and the way they were asking the questions to the participants, I was feeling impressed and saying that if I was asked this question, whether I would have been able to answer. But the way the participants were answering those questions show the preparation, the hard work, the commitment they have done for this competition. And that is because, the competition, Surana and Surana competition itself has earned the name, the reputation that here only the best will be selected. And therefore, everyone has to be best. You are getting an opportunity to take part in the international competition at Florida. That is something, at this stage in your life, something really enviable. Nowadays we are seeing a lot of moot court competition taking place, and we always feel envious that at our time we did not get this opportunity of having the forensic skills at the stage of learning itself in the law colleges. But now every college is organizing moot court competition, and now we are having international moot court competitions. So that is quite a, litigation nowadays, or the legal field nowadays, is becoming very coveted and competitive. And that shows these competitions are getting good, responses also. And the way they are preparing for it, the research which goes into their, preparation, the memorials, the case laws which they have prepared and they have presented in a very confident manner. That was something, I felt very happy about it. Sitting on the bench, we always feel that our efforts, our judgments will be just the reflection of what is argued before us. So unless the quality of the bar is enhanced, improved, elevated, the judiciary, the quality of the bench also may not be. And today's performance was a testimony or a hope that yes, the things are getting better and better. Our law students are really performing so well. Of course, the participation is so important in such competitions, and to reach up to this level is more important. We always say that winning or losing is okay. I mean, it is a matter of game, it is a matter of life, it is a matter of, taking part in the competition. But then here I would like to strike a different note that participation is important, but more important is winning also, because there is hardly a marginal difference between the first and second. But to bridge that marginal distance, to cover that marginal distance, so many efforts are required. I mean, if the marginal difference is of 1%, you have to work 100% more to bridge that distance. And therefore, that difference always remains. As we always say, winner takes it all. And therefore, the winning age is always there. I would request the participants who will be now going to the international moot court competition to exert more to ensure that they get the winning stage. I mean, and for that, I am sure they will make every effort, because today's performance gives us lots of hopes. As I said, the success of this moot court competition, the illustration, I mean, the best illustration or example is Mr. Khubchandani. I mean, if you want to reach up to that level, and all of you have got the potential to reach to that level. 11 years back, he was also a participant, but after 11 years, he is, one of the judge and having earned the reputation to become here. He has appeared in International Court of Justice. He is a name to be recognized, reckoned with. That is because, the foundation was laid in this competition. And I feel that all the participants can definitely achieve that stage with more efforts. And when you are, parent organization as your own colleges and MNLU, which has given you the platform to, and the organizers of this competition who had provided you the platform are making every effort to ensure that you touch the sky. I mean, you achieve the success which has no limitations at all. So it is great. It was great. I mean, I will not go into the merits of the subject because it is always relevant. Environment, so long as the planet exists, environment cannot lose its relevancy, because we want sustainable development. We want so many things, but how to achieve it? And that is a subject which will engage the attention of future generations also. But for me, being a part of the bench and also at some time being the part of the bar, I always look forward to the advocates, law students who will one day, come to the court, or who will they either argue the matter or adorn the bench. And then with their skill, they will evolve this law into making the lives of human beings far better and far more richer. So I look forward to all of you. I congratulate the winners who will be, everyone might be knowing who has participated in this. My colleagues will be knowing. For me, especially if you ask, it was an enriching experience to learn from them the various dimensions of the international environmental law. So many international treaties and conventions, their articles, and what is the importance, case laws and everything. And I'm sure everyone who is here must have felt enriched by this entire exercise and experience. So the winners always congratulated, and all my best wishes to the other participants and these winners also to achieve the success in the international competition at Florida also. I must congratulate the MNLU also for organizing this best event. Really, everything was done in a very professional manner. And Soham, you take the cake also because you have done it so well. And your team, which is of anchoring, everyone has done. All of them are, when I heard my CV, in my introduction, I was wondering, oh, such a beautifully written. I had not given all these, things to them, but they have done so well. I mean, everyone's introduction, everything was done in a well-organized manner. I mean, Surana and Surana are having the experience in it, and their guidance must have gone a lot of, miles to guide you also. So best of luck and all the compliments and everything. And we look forward to their success. We would like to know how far they have gone in the competition in Florida. So thank you to everyone for giving me an opportunity to be part of this competition. Moot Court gives us one more opportunity to be a judge. After retirement, that opportunity is not much. So I always enjoy to look at the talent of these young budding lawyers, and and extend my best wishes and thanks to Mr. Dr. Vijender Kumar. I'm really thankful to be a part of this prestigious competition. Thank you so much.
Thank you so much, Madam Justice, for your kind and insightful words. Now, moving on to the most awaited part of the evening, that is declaration of awards. I request Mr. A.D. Johnson Christie, Manager, Special Projects, Academic Initiatives, and Dispute Resolution Practice, Surana and Surana International Attorneys, to kindly take over and administer the announcement of results.
He has to unmute. Will you express
respected dignitaries of the evening and my dear participants, it's my privilege to be here to announce the results. As we have many categories, let me quickly do that. The fourth Best Memorial Award goes to Maharashtra National Law University, Mumbai, Varsha Venkat, Akshat Jail, Ishita Nair, and Myra Khanna, represented by the team competition code SS10. Teams, if you're available, please switch on your camera so that you are identical to the honorable judges and the dignitaries. Congratulations. The third Best Memorial Award has been shared by two teams securing equal marks, and the teams qualified for the third Best Memorial Award are Indian Law Society's Law College, Pune, and the School of Excellence in Law, Tamil Nadu, Dr. Ambedkar Law University, Chennai. The team from Indian Law Society Law College, Manpreet Singh Chugh, Zara Zafar Faruqi, and Abhishek Joshi, represented SS07. The School of Excellence in Law, HN Sri Harini, Surya SP, and Sahitya Nirupan were part of SS03. The fourth Best Student Advocate Award goes to Ananya Unnikrishnan of National University of Advanced Legal Studies, Kochi. The Best Student Advocate Award has been nominated according to the scores they obtained in the preliminary rounds. The third Best Student Advocate Award goes to Piyush Gupta of National Law School of India, University, Bengaluru, represented SS01. The team placed third of this competition are Nalsar University of Law, Hyderabad, Vanshika Gudipalli, Kusum, and Naushin Liaquat, representing SS01. The second Best Student Advocate Award goes to Samad Srinivas of OP Jindal Global Institute of Eminence, deemed to be University, represented SS08. The team placed fourth in this competition is Indian Law Society's Law College, Pune. The team members Manpreet Singh Ashok, Zara Zafar Farooqi, and Abhishek Joshi, SS07. The second best memorial award goes to National University of Advanced Legal Studies, Kochi. The team members Adil Mujammad Saeed, Ananya Unnikrishnan, and Snigdha Raja, SS04. The best memorial award has been awarded to Symbiosis Law School, Hyderabad.
Minute.
Urugu Tanvi Lakshmi, Abir Juvarkar, and Aditya S. Yadav from SS06. The Best Student Advocate Award goes to Arth Joshi from the National Law School of India University, Bengaluru, SS12. And the big announcement of the top two teams. The judges had a very good session with the teams. The winners are Maharashtra National Law University, Mumbai, Varsha Venkat, Akshay Jewel, Ishita Nair, and Myra Khanna of SS10. SS10 are the winners, and the runner-up team, OP Jindal Global Institution of Eminence deemed to be University, Kairen Korea, Samad Srinivas, Abhishri Madda, SS08. Congratulations to SS10 and 08. The best speaker of finals, the best speaker of the finals for today is Varsha Venkat from MNLU, Maharashtra National Law University, Mumbai. Ms. Varsha, are you there? Respected judges, and another award, we also honored of providing the Spirit of Surana Award. This award is to symbolize the holistic excellence in camaraderie and performance. The participants in the competition had casted their votes for the team that epitomizes the Surana Spirit of Award under the following categories. Based upon the excellence of intellect and astuteness in argumentation, spirited and healthy competition, team solidarity, and goodwill and harmony with other teams. Based upon the nominations, SS03, School of Excellence in Law, Tamil Nadu Dr. Ambedkar Law University, Chennai, has been awarded the Spirit of Surana Award. The team members SN Sri Harini, Surya SP, and Sahiti Nirupan. As for the World Championship rounds, the winners and runners of today, Maharashtra National Law University, Mumbai, and OP Jindal Global have been qualified from the SAARC Regional South rounds. The teams will be required to undergo, the memorials of the teams will be required to undergo an generative AA check by the Stetson International. The team who had not used the product of an AA hallucination will be qualified, and if they find anything, they will not receive the invitation. However, the World Championship round, as for now, is being qualified by the two teams in Maharashtra National Law University, Mumbai, and OP Jindal Global University. Thank you.
Heartiest congratulations to all the winners. As we reach the conclusion of the event, I, on behalf of the entire team, Would like to thank all the faculty advisors for their invaluable support and cooperation throughout the event. I now request important strength, our faculty advisor, Dr. Divita Page ma'am, to kindly deliver the vote of thanks.
A very good evening to one and all. It is my honor to propose the vote of thanks on the occasion of the valedictory ceremony of the Surana and Surana SAARC Regional South Rounds of the 29th Stetson International Environmental Moot Court Competition 2025. On behalf of MNLU Nagpur, I would like to begin by expressing our deepest gratitude to our esteemed chief guest, Her Ladyship Honorable Srimati Justice Shalini Phansalkar Doshi, former judge of the Bombay High Court, for gracing this occasion with her presence and for judging the final round of the competition. Ma'am, your invaluable experience and wisdom have truly elevated the scholarship of this competition. I extend my most heartfelt gratitude to our special guests of honor, Honorable Shri Justice M.N. Gilani, former judge of the Bombay High Court, Professor Dr. Bharat H. Desai, Director of the Institute of Advanced Studies in International Law and Diplomacy, Dr. B.P. Neel Ratna, Advocate Supreme Court of India and Managing Partner, Enviro Legal Defense Firm, New Delhi, and Mr. Mohit Khubchandani, International Disputes Resolution Attorney. The presence of our special guests of honor and their remarkable contributions to the field of law and environmental governance have been a source of immense inspiration to all of us. We are deeply grateful to all of you for gracing this ceremony and for judging the final round of the competition. My sincere gratitude extends to Professor Dr. Vijender Kumar, Honorable Vice Chancellor of MNLU Nagpur. Sir, your vision, leadership, unwavering support have been the cornerstone of this competition's success. Your constant encouragement inspires us to reach new heights and is the driving force behind the organization of this competition. A special note of thanks to Mr. Preetham Surana, Partner Dispute Resolution and Head of Academic Initiatives at Surana and Surana International Attorneys, for his guidance, insightful address, and steadfast support. Sir, your remarkable vision and leadership have been instrumental in setting the gold standard for organizing international moot court competitions over the years. We are truly honored by your collaboration in hosting these rounds, and your exceptional foresight and pioneering efforts have elevated this competition into a globally prestigious platform. We are likewise grateful to Mr. A.D. Johnson Christie, Manager Special Projects, Academic Initiatives and Dispute Resolution Practice at Surana and Surana International Attorneys, and their entire team for their dedication, collaborative efforts in organizing this prestigious competition. I extend my special thanks to the esteemed judges of the semi-final rounds, Honorable District Judge Bhushan Shirsagar, Professor Siti Hafsai Idris from University Technology Mara, Priyank Jain from SED Fund, Pooja Chatterjee, partner at King's Tub and Kasiva, Mr. Abhishek Jain, associate at Cyril Amarchand Mangaldas, and Professor Erin Okuno from Stetson University. Their thoughtful deliberations and feedback have been invaluable in shaping the participants' experiences and legal acumen. A sincere acknowledgement also goes out to all the judges of the quarter-final and both the preliminary rounds for dedicating their time and expertise to ensure that this competition was a learning platform for all. We are profoundly thankful to Sri Vivek Gavhane, Registrar of MNLU Nagpur, for his institutional and administrative support. I extend my heartfelt gratitude to Dr. Shilpa Jain ma'am, Associate Professor of Law, MNLU Nagpur, for being an exceptional mentor and a guiding force behind the Moot Court Committee. It was her vision and initiative to establish this collaboration with Surana and Surana International Attorneys for hosting these regional rounds. I also express my sincere thanks to Professor Sania Agrawal, Assistant Professor of Law at MNLU Nagpur, and my co-faculty advisor of the Moot Court Committee for her relentless support throughout. Finally, I would like to also thank the entire teaching and non-teaching family of MNLU Nagpur, the IT committee for ensuring smooth and glitch-free virtual execution of these rounds, and to all the participants representing some of the most exceptional law universities across the region for all their efforts, commitment, and sportsmanship. My very heartfelt gratitude goes to finally the student members of the Moot Court Committee, led by their very enthusiastic convener, Mr. Soham Kaye. and also to the former convener of the committee, Mr. Jatin Srivastav, whose efforts laid the groundwork for the successful organization of this competition. To each one of you student members, Charita, Srishti, Atharva Giratkar, Devansh, Apeksha, Arya, Harshil, Divya, Srivatsa, Ayush, Indira, Tarang, Utkarsh, Atharva Pagnis, Annamitra, Gershon, dear student members, it is your countless hours, sleepless nights that have made this event a success. To all our student volunteers and courtroom managers, a big thank you for your precise planning, to your seamless coordination. No detail was left unattended. Thank you so much for your efforts, and we are all immensely proud of you. Thank you finally also to our articulate students, Manashwini, Samal, and Arya Mishra, for impeccably conducting this ceremony. And as we draw this event to a close, I hope all students depart not just with the experiences of a well-contested moot, but with friendships, learning, and memories to cherish. Thank you so much, everyone, and have a wonderful evening ahead.
Thank you.
Thank you.
Thank you.
Thank you for the kind words, ma'am.
Thank
As we
you.
draw curtains on the Surana and Surana SAARC Regional South Rounds of the 29th Stetson International Environmental Moot Court Competition 2025, we celebrate not only the winners, but the remarkable intellect, dedication, and advocacy displayed by each and every participant. As you log off today, carry forward the spirit of the moot, one of resilience, innovation, and unwavering commitment to a sustainable future. Thank you so much.
Thank you. Thank you to
Thanks
everyone.
all.
Thank you.
Thank you, everyone.